Ms. Trethewey, you may call your next witness, please.
Judge, at this time, the defense will rest.
All right, thank you. Members of the jury, the state and the defense have closed their cases in chief. Georgia law provides that when a defendant has raised a defense of not guilty by reason of insanity, the law provides that a third party make an evaluation of the defendant. By third party, I mean I say psychologist that is not associated with either the state or the defense. The third party evaluator in this case is Dr. Jacqueline Zom. You may have heard her mentioned in the testimony earlier. She is here this morning. Both the state and the defense have stipulated to her qualifications as an expert, and she is going to be testifying for you. Each side will have the opportunity to ask her questions. So, Dr. Zom, you can come forward. Yes. If you will place your left hand on the Bible and raise your right hand, do you swear or affirm that the testimony you're about to give in the matter pending before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. If you will state your name for the record, please.
My name is Dr. Jacqueline Zom.
All right, and Ms. Gropper, I'll let you proceed.
Good morning.
We've stipulated to your qualification as an expert, but because the jury's had the benefit of hearing from other experts and their background, could you tell the jury a little bit about your education and experience with regard to forensic psychology?
Yes, can I just ask, is this too loud? Am I
No.
vibrating anyone's eardrums?
I think it's okay.
Okay.
I can turn it down a little bit if you're uncomfortable.
Thank you. My undergraduate degree is from Georgia College and State University. I have a Bachelor of Science with a major in psychology. My graduate training is from Georgia School of Professional Psychology at Argosy, Atlanta. Throughout my graduate training, we're first required to become generalists as psychologists. So we all have very similar training in terms of our graduate school training. However, during all of my practicum and in-person kind of hands-on learning opportunities, I focused on evaluation and assessment. So that has been where my training has primarily focused. My residency was at Mississippi State Hospital, which is right outside of Jackson, Mississippi. In Mississippi, it's similar to Georgia Regional. It's the state psychiatric hospital where individuals are treated for severe and pervasive mental illness, including individuals who have been forensically committed or who have been found in need of treatment to be restored to competency, or are being housed after being found not guilty by reason of insanity. So my residency included forensic rotation on a forensic ward where I provided group and individual counseling for competency restoration, as well as involvement in evaluations to determine both competency to stand trial and criminal responsibility. During that time, I also completed an external private rotation that focused on the similar referral questions. Since that time, I came back to Georgia, completed my postdoctoral training at Georgia Psychological, which is where I was employed when I initially conducted this evaluation. Throughout my time there, I served as clinical director over a small clinic of approximately 5 assessors, evaluators. Most of my work there involved juvenile court as well as some family court and some cases similar to this one. All of my experience since completing my graduate training has involved evaluation and assessment, so that is kind of where my expertise lies.
Okay, and when you use the terminology evaluation and assessment, what do you mean by that?
Psychological evaluation, psychosexual risk offender evaluations, domestic violence, substance abuse, questions regarding parental fitness or risk for child abuse, as well as criminal responsibility. Also, the question that is before this court, whether someone is criminally responsible, although those do come to us far less frequently because they are not presented to the court in as higher numbers as we see these other referral questions.
Okay, so the criminal responsibility assessments you do come in smaller numbers than the other types of assessments?
Far smaller numbers, yes.
Okay. Thank you. I want to talk to you a little bit about your evaluation in this case. The court's kind of told the jury that the law provides that a neutral third-party doctor will conduct an evaluation. So we've never worked together before. Is that fair?
That is fair.
Okay. And you completed a 38-page report in this case, right?
That is correct.
And tell the jury a little bit about what you reviewed in this case in terms of collateral documentation apart from your actual evaluation of Ms. Driver.
Okay. For this case, I received extensive collateral documentation. I received, I believe it was approximately 1,200 pages of documentation pertaining to medical treatment. I received what I believe were all of the interviews of the parties who were present at the time that the alleged event occurred, including the interviews with Mr. Benjamin Ben McHale, the two ladies who were present in the home, Jessica and Sarah. I received interviews of Ms. Driver herself that were conducted by Detective Cruz, and I received the police narratives of all of those interviews as well as the actual interview itself. I also received some documentation of a handful of calls that were placed from the jail. I did not receive previously completed evaluations.
Okay. And your statement about not receiving previously completed evaluations at the time that you were conducting your evaluation, what was the reason for that?
So I'm not sure if they would have been provided to me or not, but I did request in this case that they not be provided to me, given that my role was to be a neutral evaluator. So I did not want to see the work of a previous evaluator and their conclusions.
Okay. And so did you conduct your evaluation and review of the material and complete this 38-page report, having no idea what the other doctors in the case had found?
So I was told that at the onset of the case, I was told that Ms. Driver had been evaluated twice, and that both evaluators agreed that she was suffering from severe mental illness, had a significant mental health history, but that they had differing opinions in some areas.
Okay. But beyond that, you had not reviewed their reports and
no.
Specifically requested that you not receive them so you could conduct your independent analysis?
That is correct.
All right. And did you also, as part of your review of this case, receive information about things like her cell phone searches?
I did.
Okay. And any other potential video documentation?
I received a video that was taken, I believe, by Ms. Driver or by someone with Ms. Driver that occurred during what appeared to be a point where her daughter had been taken from her and she was not with her daughter and was attempting to go to a place to meet the father in order to be with her daughter.
Okay. I want to talk to you about your evaluation, your actual evaluation of Ms. Driver and your interaction with her.
Actually, can I add one more additional that I did not mention? I apologize. I also received what I believe was a transcript, I'm sorry, not a transcript, but an audio recording of her conversation that appeared to have been taped by Mr. Benjamin McHale, where he had recorded various statements she had made in the time leading up to the alleged events.
Okay. And after you review, any idea how much time you spent reviewing all of that collateral documentation?
I would say between 10 and 16 hours.
Okay. And after did you review all that before you went to meet with Ms. Driver?
I did not review all of it before I went to meet with her. I believe that I had received it and had reviewed some, but I had not reviewed all of it before I met with her. Much of it was also reviewed multiple times.
Okay. And you, on page 19 of your report, you discussed sort of your behavioral observations and mental status of Ms. Driver when you actually went to go see her at the Cherokee County Adult Detention Center?
Yes.
All right. And is it fair to say that you notated in your report that you found Ms. Driver to be of above average intelligence?
I believe her to be of above average intelligence, yes.
And why did you reach that conclusion?
Well, she, reported to have done well in school and excelled academically before she dropped out, but also her communication is very sophisticated. Her language, her use of words, her vocabulary and use of vocabulary in conversation is, I believe, to be above average, as well as she's very articulate and detailed in describing things in a manner that would be consistent with at least average, more than likely above average intelligence.
Okay. You also indicated in your report that she was very much aware of the legal details surrounding her case. What did you mean by that?
She was very much aware that I would be conducting a third evaluation. She was very much aware that she had been evaluated previously on 2 different occasions. She was very much aware that my report would not be confidential, that it would be provided to the court, to the attorneys. She was very much aware of how to reach her attorney should she need to do so. She was also aware in a manner that was quite unique for someone in her situation, in that she spontaneously articulated that 3 years had passed since the offense occurred, alleged offense, and she recalled in much greater detail in terms of her own symptoms and what was going through her mind at the time in far greater detail in the previous evaluations that occurred sooner after the alleged event. So she herself had some concerns regarding, I guess the appropriate word would be the validity of this evaluation, given that so much time had passed.
Okay. And did you notate in your report sort of your lack of concerns with regard to her memory and her ability to recount certain things?
I perceived her to be able to recall things in great detail. I perceived her memory to be she was able to articulate very things well and seemed to have a very vivid memory for the circumstances leading up to the alleged offense.
All right. And I want to talk to you a little bit about your report as it relates to sort of getting background information about Ms. Driver before you kind of got into the substance of the offense and her mental state surrounding the offense. What did she describe to you about her childhood?
She described basically that she had grown up. She didn't use the word loving. It seemed as though her home may have not been particularly, there may not have been a lot of overtly expressed affection, but she seemed to perceive that she was well cared for, did not describe abuse by her parents, and perceived that her needs and most of her wants were provided.
Okay. She described herself as being boy crazy?
Yes.
Okay. She told you about moving in with boyfriends when she was 15 years old and then with a second boyfriend in 2017?
Yes, she described herself as being a difficult child to parent.
Okay. And she reported to you a lot of history of drug use with cocaine, ecstasy, MDMA?
She did report an extensive drug use starting at a very early age.
Okay. And she indicated that she had gotten some of those drugs from her boyfriends, but also gotten some of those drugs from her brothers?
I believe primarily her boyfriend. Her brothers maybe on a couple of occasions was my perception.
Okay. And she reported to you also that she was sexually abused by both of her brothers?
She didn't use those terms explicitly. It seemed that something had occurred. It didn't seem that she perceived it to be a malicious intent.
Okay. She told you that her brothers didn't know what they were doing when they hurt her? Okay. Specifically with regard to her relationship history with the 2 boyfriends she lived with prior to meeting Benjamin, isn't it true that she told you that she was becoming increasingly spiritual while she was dating them and feeling guilty about the life decisions she was making?
She did.
Okay. Now, I want to talk to you a little bit about, obviously she told you she met Benjamin and she started a relationship with him when she was 17. Is that right?
Correct.
Okay. What did she tell you about sort of the relationship dynamics or the cult dynamics involving Jessica and Sarah and their feelings toward one another?
I believe her language, and I'd have to look back at my writing to be 100% accurate, but I believe the language that she used was that they came on soon after her, and initially she was okay with it. It seemed that contention primarily surfaced after the birth of her daughter when she wanted to live as a family.
Okay. And just with regard to language, is it fair to say that on page 26 of your report, she told you that by the time the baby was 7 or 8 months old, she hated the other wives because they wanted to have a child with Z, and they hated her because she had a child with him first?
Correct.
Okay. And isn't it true that she expressed to you multiple times that you document in your report her desire for stability and her desire to be able to give Hannah a normal life?
Correct.
And one of the things that you documented in your report is that he had kept promising her that he would give her a house and a community to raise her baby in.
Yes.
Okay. And did that seem to be of significant importance to her surrounding the dynamics of that relationship?
It did.
Okay. Isn't it true that in your evaluation of her, she had an extensive amount of knowledge surrounding sort of the, I don't know what to call it other than fraudulent conduct of the cult?
Can you repeat that?
She had an extensive knowledge of the conduct of this organization, how they got money, how they got cars, how they planned to get houses.
She did.
Okay.
She did, and it was very complex, such that it was confusing to me.
Okay. Did she try to explain it to you?
She did.
Okay. And in fact, she told you that they had all applied for COVID loans under each of their trusts, but she was the only one that got approved.
She did say loans. It may have been COVID. I would have to look back at my exact language, but I do recall the mention of loans that seemed to be very large sums of money that they had all applied for, and she was the only one who was approved, yes.
Okay. And she indicated that they had RVs and vehicles that they had no license and they had no insurance, but they would always get out of it when they got pulled over because they had the trust documentation.
Correct.
And she also told you that their plan of going from North Carolina down to Florida was because they planned to steal 2 houses with their trust that they located on Zillow.
Correct.
And she also indicated to you that they had previously gotten free vehicles utilizing this trust.
Correct.
And did she seem to have an extensive knowledge of sort of the inner workings of that?
She did.
Okay. I want to talk to you next about maybe some of the things that she represented to you that were not supported by the collateral documentation. I noted that one of the things in your report was that she told you when she was admitted into the hospital that she weighed 80 pounds. Is that fair?
I can't recall if she said when she was admitted to the hospital or or during the culmination of her struggles that led up to the alleged events, but she did note losing significant weight and weighing approximately 80 pounds.
Okay. And if your report said that she said when she was admitted to the hospital she was 80 pounds, would you have any reason to disagree?
I would not disagree with that.
Okay. And you actually notated in your report that you had the medical records, and her medical records indicated that she had normal BMI, right?
Correct.
And in the medical records, it also indicates that she wasn't 80 pounds, she was 113 pounds upon admission.
Yes, it had the kilograms, and I did have to do the conversion online. But yes, that is what I noted from her medical records.
Okay. So she had underreported to you that she was 33 pounds skinnier than what she actually was.
It seemed so based on the documentation that I had in the medical records as compared to her self-report.
Okay. That she was exaggerating how thin and frail she was?
That she was exaggerating or either had misperceived or either was representing a different point in time.
Okay. I want to talk to you about your review of her searches. I think you documented several of them in your 38-page report.
I did. Some were repeated and some were similar, so I don't think that I documented all of them, but I did document many of them, yes.
Okay. And you would agree with me that on November the 22nd and November the 23rd, she started searching things about whether she was sinning being with a married man, whether she was sinning having a baby with a married man.
Yes.
Okay. Was this consistent with her statements to you that she was starting to question sort of the ideological views of the cult?
Yes.
Okay. And those things were not related to any delusion she was having. She just indicated that they were related to her questioning the value system of the cult?
That was my perception, that she was questioning the beliefs that were being taught within the group.
Okay. And that was on November the 22nd, November the 23rd?
I wouldn't disagree with that. I'm not looking at the date, but that seems correct.
Sorry, do you have your report there?
I do.
It's on page 12. If
Thank
that's
you.
helpful.
If you can reference the page.
Yeah, of course. So you're aware that on the 25th of November, 2 and 3 days after she was searching about whether she was sinning being in this group, she searched killing someone to save them.
Correct.
All right. And then you're aware that subsequently, 5 days after that, she was researching how to snap a neck and looking at websites about how hard it was to kill someone by breaking their neck.
Correct.
Okay. And then you're also aware that on the day that she killed Hannah, December the 8th, she was Googling how to get a bus ticket for a 13-month-old.
Correct.
Okay. And you indicated that you had seen the video from November the 27th where she says, "My name is Chloe Driver, he has my baby, I'm being forced to go against my will." Is that the video you're talking about?
Correct.
All right.
That is.
And she represented to you that she went back to him and her plan was to get her baby and run, right?
Correct.
Are you aware that after she went back to him, she did get her baby and then she returned to her mother's house for a couple of days?
I am.
Okay. And then he wanted to go look at some property in Knoxville, so she left with him again to go look at property in Knoxville.
Yes.
Okay. So the last time that she returned to him, she actually had the baby with her at her mom's house, and she went to him to go look at property.
That was the way I interpreted her narrative, yes.
Okay. And in your review of all the medical records, so you had 1,200 pages of medical records and collateral information. Is it fair to say that Ms. Driver, of her own volition, at multiple times refused any type of medication to treat any type of psychiatric condition?
That was reported in the medical records from the hospital, yes.
Mm-hmm. And that she specifically reported that it was against her belief system to take any of those medications?
That's what the hospital records indicate, yes.
Okay. Now, I want to talk to you about specifically the delusions that she reported that relate to Hannah. Well, first let me, let's do that. It's on page 31. Is it fair to say that as it relates to Hannah and sort of what she told you about her motivation for committing the act, that her delusion was that when she would breastfeed Hannah, she would sort of give Hannah all of her pain and all of her sin?
Yes.
Okay. And did she attribute that to be sort of one of the significant things telling her that she needed to kill Hannah?
It seemed to be a part of the rationale in her mind of why she needed to kill her daughter, yes. The narrative was very complex, and because the idea is not rational, it's very hard to restate it in terms that equate to rational thoughts. But that seems consistent with the narrative that she portrayed, yes.
Okay. And so you said that it was kind of hard to follow because there was more of a narrative than a concise individual
Correct.
thing. Was the overarching theme of the narrative she gave you that she wanted to kill Hannah to save her?
Correct.
Okay.
To save her from a life of pain and catatonic depression and abuse.
Okay. And is it fair to say that some of that was based upon sort of the reality that she was living in the cult dynamic?
It did seem that the reality in which she was living was all wrapped up in her thought processes as well. While some of the thoughts were irrational, some of the thoughts of feelings of oppression and isolation were indeed what she was experiencing.
Okay. So the isolation and oppression were maybe more reality-based, and then she maybe had some irrational thinking sort of overlapping with her odd ideologies?
Yes, and while it didn't seem that exact narrative was part of the teaching of the group, there was a narrative of that this small number of women in this small chosen group were responsible for the sins of the world. So there was that component as well, that some of the narrative that she had taken on had been a part of the teachings.
Okay. But as it relates to whether the beliefs that she articulated to you are religious teachings based and like genuinely held beliefs, or whether they're over here in the irrational mind that she's on her own independent thinking, whether they're in either category, did everything she articulate to you as her motivation relate to her essentially feeling like she needed to save Hannah?
Yes.
Okay. Did she ever articulate to you in any way that she felt threatened by Hannah?
No.
Did she ever articulate to you that she felt like she needed to defend anybody against Hannah?
No.
Did she ever indicate that Hannah was a danger to anyone around her?
No.
I want to talk to you specifically about what she told you. Obviously, would you agree with me that when we're talking about the question of what somebody's mental state is at the time they commit the crime, we have to look at the crime itself?
Correct.
And that's important for you to get as many details as possible surrounding the actual incident?
It's important to get as many details as possible surrounding the incident in order to compare the individual's narrative to what is indicated in collateral sources, to hopefully understand on some level how lucid they were, what was their decision making like, and what were they thinking. Yes.
Okay. And when you say how lucid they were, what do you mean by that?
How clear were their thoughts? Were their thoughts reality-based, and what were their thought processes overall?
Did you, and I can't recall, so refresh my memory, did you request or review any of the officer's body cam footage in this case?
I did not request it.
Okay.
I did not review it. In fact, I did not receive it, likely because I did specifically ask not to see visual images.
Okay. But if she was making statements on the scene minutes after she stabbed Hannah, would those things be relevant to how lucid she was and what her mental state was at the time?
They would be, and I believe some of those statements were articulated in the narratives, which I did review.
Okay. So you're aware that she said things on the officer's body cam like, is that it? Is that goodbye? With relation to her daughter dying?
I don't recall that specific statement. I do recall I want to see her one last time, and I think that is documented in my report.
Okay. And do you know anything about her making statements of let him be with her, let him be with her?
I do recall that.
Okay, and that's when officers were trying to make Benjamin leave the room?
I do recall that.
Do you recall any information about the EMT calling Hannah a boy and Chloe Driver correcting her and saying it's a girl?
I do not recall that. I don't dispute that, but I don't recall that.
Okay. Do you recall any information about something coming over the officer's radio saying the baby's being transported, and Chloe responds by saying, is she alive?
I don't specifically recall that. I recall that question after she was receiving treatment shortly after in the hospital when she had first started to seem to regain consciousness, but I don't recall that from the scene as they were leaving the home.
Okay. What did she report to you about from the time she entered that room with Hannah? How much information and detail did she report to you? It's on page 36 of your report if you want to reference it. About what events took place in that room, what she did.
She was very detailed in her description of what took place in the room, and her detail was provided spontaneously, meaning that I did not ask have to ask a lot of guided questions. It was a very much a spontaneous narrative that she recalled becoming distressed. It seems that she was very much aware that she was having these thoughts of hurting herself and Hannah, and therefore did not want to be in a room by herself, and had attempted to go into the room with the other women, and Ben Michael motioned for her to go into the room alone. And she recalled Hannah not having on a diaper, only having on the rubber cover for the diaper, and asking for a diaper and a shirt, I believe. She recalled breastfeeding her. At some point prior to this, she'd gone back downstairs to get the knife, came into the room, locked the door, recalled getting the dirty shirt when she had asked for a clean shirt in order to make the child presentable, as they were anticipating going to a 12 Tribes meeting at some point in the immediate future. And she recalled getting the dirty shirt and feeling like that was another indication that she was supposed to do this. She was supposed to take her life in Hannah's. She recalled feeding her, calmly lying her down, and then taking the knife and attempting to kill both Hannah and herself.
Okay. And she told you that sort of Benjamin throwing her the dirty shirt was kind of what triggered her, that she wanted to kill herself and kill Hannah.
It was one of the things that triggered her, that she described in this series of events in the hours and minutes proceeding. But yes, that I believe was the last thing that she described as being a triggering event.
Okay. And in your report on page 36, it says, from that moment on, I snapped, talking about the dirty shirt. Would those be her words?
Those are her words.
Okay. And you indicated that she said that she fed Hannah, and isn't it true that she said she fed her and then she laid her down on the bed and she was happy?
Yes.
Okay. And what did she say happened next?
Do you want me to read it word for word, or do you want me to recall from the best of my memory?
Well, I guess I'll kind of walk you through it.
Okay.
She indicated that she went down and grabbed a knife from the kitchen, right?
Mm-hmm.
And she told you that she just grabbed a random knife out of the knife block and she didn't even look at it, right?
Correct.
And she went upstairs and she locked the door.
Correct.
Okay. Did you engage in any conversation with her about why she locked the door?
I did not.
Okay. And she indicated that she played a lot of video games, and that in the video games that she played, when you stab someone, they die immediately, right?
Correct.
And so she says, I have the knife, and I'm up here, and I'm up there. I don't know where to stab either of us, and I think the throat might kill us immediately. Is that what she told you?
Correct.
Okay. And so then she said she breastfed her, and she laid her down on the bed, and she was happy. Are you aware that she told another evaluator that when she laid her down on the bed before she stabbed her, she apologized to her?
I was not aware of that.
Okay. Did she tell you that?
She did not. I do not recall her telling me that. I believe if she had told me that, it would be in my report in this paragraph.
Okay. And she then told you, I stabbed her in the throat, but she was not dead. She is just quiet and bleeding out, right?
Correct.
And I stabbed myself in the throat 3 times, and then you put in your report she made a twisting motion to demonstrate. What do you mean by that?
She kind of demonstrated what she was articulating verbally.
Okay. And she told you that at that point, after she had stabbed Hannah in the neck and stabbed herself in the neck, she's standing there wondering, why are we not dying?
Correct.
And at that point, she indicated she heard Z coming upstairs.
Correct.
And that he opened the door, and before he walked in, she was confused about why they weren't dying immediately, and so she tried to stab herself one more time in the heart.
Correct.
All right. And she indicated that in that moment, she thought that they were coming into the room to save them.
Correct.
And she didn't want to be saved because she didn't want to deal with all the pain that she imagined in the world.
Correct.
Okay. Safe to say that her memory about those events was very intact?
That was, yes.
you said, you want to assess whether somebody is lucid, their ability to sort of, what their thought process was, like why is it significant and important that somebody has a detailed memory of a particular event?
Well, during psychotic states, people can oftentimes be confused. Sometimes they are not. They can oftentimes be confused. So it's important to assess their level of confusion, how much they can recall. Also, it's very important to, one of the things we're always looking for in cases such as this one is the person a reliable informant, or are they fabricating information and fabricating symptoms in order to achieve a desired outcome. So it's important to compare their narrative to that of collateral sources. So the primary reason for understanding their description of the events is, one, to determine if it aligns or does not align with other sources of information in effort to determine if the person seems forthcoming or if they seem to be presenting information in effort to gain a desired outcome.
Okay. With regard to information that she may have reported to other evaluators, if she told Dr. Ballard when specifically asked if she knew whether her behavior was wrong, yeah, as soon as it happened, I regretted it. I thought I shouldn't have done this. This was not supposed to happen. Would that be consistent with how she presented to you?
Yes, she didn't state anything to me that indicated otherwise.
Okay.
It's not inconsistent with what she described to me.
Okay. And if she told Dr. Garrett she recalled apologizing to Hannah and telling her how much she loved her before she stabbed her, but she was at peace with it, but that she knew it was wrong from the beginning, would that be inconsistent with what she reported to you?
It's not inconsistent with what she reported to me.
Okay. And doctor, I took note in your report that you did not diagnose her with anything.
That is correct.
Why not?
So the experts in the field of psychology, the individuals who are experts on these types of evaluations, differ in their own opinions as to whether or not we should render a diagnosis in this type of evaluation. One school of thought says that a diagnosis helps the jury and the attorneys and helps psychologists in general to understand a person's mental state at the time. Even though it doesn't necessarily describe their mental state at the time, it helps us understand a set of symptoms and helps explain behavior. The other school of thought says that the diagnosis can be confusing because the diagnosis doesn't necessarily align all the time with mental state at the time of the offense, and people can make certain assumptions based on diagnosis alone and may make inadequate judgments. So in other words, it can be reckless to do so because a diagnosis can communicate to a lay person information that is not what we're intending.
Okay. And what school of thought were you in not diagnosing her in this criminal responsibility report?
So I did not render a diagnosis. My reason was it's not critical to answer the referral question. The referral question pertains to her mental state at the time of the offense, and a diagnosis would not necessarily explain her mental state at the time of the offense. The diagnoses that I considered, one, can have people can have very negative assumptions when they see this diagnosis. And then another diagnosis, people automatically make assumptions about psychotic symptoms. So without having the opportunity to explain her mental state, I did not want for the diagnosis that I rendered to communicate information about what I perceived to be her mental state at the time of the alleged offense. I prefer to articulate that verbally rather than to put a diagnosis on a report and possibly not have the opportunity to explain it.
Okay. And is your thought process on that because whether or not she has a diagnosable mental illness is a question of medicine, and whether or not somebody is criminally insane is a question of law.
Correct.
And somebody can have a mental illness and not be criminally insane.
Correct.
And is that what you mean by sort of creating confusion?
In part, and someone can assume that a diagnosis means that mental health symptoms would not account for behavior at the time. So both situations, what you just said, and conversely, that someone could assume that other behaviors account for, that other explanations account for behaviors at the time of the alleged offense other than mental illness.
Okay. And I'm almost done, doctor, but I just want to sort of wrap up. You told us already that none of her delusions related to Hannah being a threat, harm, danger, or peril to her or anyone else, correct?
Correct.
And that all of her delusions related to Hannah and her need to kill Hannah was to save Hannah. Is that correct?
The delusions that involved Hannah seem to relate to her need to kill Hannah to save her, yes.
Okay. I don't have any other questions. Thank you.
Thank you.
Hey, good morning, Dr. Zahn. How are you?
Well, sir, thank you.
Just to follow up on that last set of questions, to be clear, Ms. Driver's delusions were not simply related to killing her daughter, correct? They were killing herself and her daughter, right?
Correct. And there were many delusional thought processes as well, but those that pertain to the alleged offense pertain to killing both herself and Hannah, correct?
And the action she took on December 8th was consistent with that delusion, meaning she stabbed her daughter and also attempted to kill herself, right?
Correct.
Okay. So let's kind of walk through your background. I may have missed this a little bit. You indicated that a lot of your forensic work after obtaining your doctorate was in Mississippi. Is that right?
Not after, before.
Before, okay.
Training.
How long were you there in Mississippi?
A year.
A year?
Correct.
And when did you get your psych D? That's called.
I think I graduated in 2013. 2012, I'm sorry.
Forgot a page. 2012, your PsyD, correct?
Correct.
Okay. And then after that, you spent a year in Mississippi.
The year was before.
I'm sorry.
That's okay.
So 2011-ish in Mississippi.
2011 to 2012, correct.
Got your PsyD
in 2012, the end of 2012.
And then you came back to Georgia
correct.
to start practicing.
Correct.
Okay. Did you begin work at that point in time in 2012 with Georgia Psychology?
I did not. I did not return to work immediately, and I did not begin work. And well, I did briefly. I did not continue. I did not continue continuously during that time frame.
Okay. So who did you first work for when you
Georgia
started?
Psychological.
Okay. And when was that? When did you start with them?
2012, end of 2012 or beginning of 2013.
Okay. So I guess I'm slightly confused there. How much work did you do for them?
So I worked with them for a year. I think there were about 3 years that my clinical work was minimal, and then I resumed work with them in 2015, and that is where I remained until this summer, until July 2024.
Okay, and I think you opened your own practice.
That is correct.
Okay. All right, so you had a few years there where you weren't doing as much work with them.
Correct.
But got back to that in 2015. Okay, since 2015, I think your testimony earlier was you've done a lot of different evaluations at Georgia Psychological.
Correct.
Just general psychological evaluations of individuals, right?
Yes. Most of my work with Georgia Psychological pertained to child custody, child protective services.
Defects, as we refer to it.
Yes. Also some disability adjudication
Okay.
referral questions.
And you said that you had much less frequent requests for criminal responsibility exams that you've done in this case, right?
Correct.
How many criminal responsibility exams do you think you've done since 2015?
Since 2015, only a handful. I was heavily involved in criminal responsibility during my internship. Since 2015, only a handful. I would say 4 or 5.
Okay. And the one that you've conducted in this case with Ms. Driver, that was just in the last 6 months, right?
Correct.
You evaluated her in May of 2024.
Correct.
Okay. Of the, you said 4 or 5 roughly criminal responsibility exams?
Correct.
Is this the first exam that you conducted that you've actually had to testify about?
This
in a
is the
court
first
proceeding?
time. No, it isn't. This is the second that
Okay.
I've provided testimony.
Okay, so it's fair to say, Dr. Zahn, that, and you're familiar with this in conducting forensic evaluations back in Mississippi as well, many of the criminal responsibility exams that you would conduct, you generally do not testify about those in court, right?
Correct.
Because ultimately you believe that the person does not exhibit significant signs to be deemed insane under law. Is that right?
Yes, statistically, the number who are deemed, well, first, it's not a defense that is often presented, and secondly, the number who are deemed to fit the criteria is very small, even as a percentage of the number who present with that defense.
Correct.
So yes, that is correct.
Okay. And you have conducted criminal responsibility exams on behalf of defendants in cases. Is that fair?
Yes.
Okay. And that process is typically where, based on the given facts of a case or circumstances that a lawyer has seen based on reviewing the evidence, they believe there might be an issue with a client and they are requesting you to make an evaluation, right?
That is my understanding of how it would come to me as a referral, yes.
At no time does any defense lawyer call you up and say, Dr. Zahn, I need you to find that this person is diagnosed with these mental health disorders so that we can create this defense.
No, no one has ever said that.
Okay. So whether or not to pursue a not guilty by reason of insanity or a competency evaluation in a case is based on the defendant's mental state that is presented in the facts of a case.
That is my understanding, absolutely.
Okay. Now, in this case, you indicated that you looked at various collateral sources that were provided to you, I think, by the DA's office.
That is
right?
correct.
And the list of those included her Chloe's medical records from Kennestone, right?
Correct.
Included the interviews from law enforcement, both with Ms. Driver and some of the other witnesses that were at the home at the date of this incident, right?
Correct.
You reviewed some cell phone searches, right?
Correct.
Some jail calls from Ms. Driver at the jail.
Correct.
And then this video that she recorded at the end of November with respect to going back to get her daughter, right?
Correct.
Did you review police reports from Asheville?
I did.
Okay. Was that 1 or 2 different police reports? Do you recall?
I think there is 2, but I would have to reference my report to say that with certainty.
Okay. Let me ask you this way. Do you recall an incident where Ms. Driver was running out into the road
Yes.
trying to get away from Mr. Benyamin?
I do recall that.
Okay.
I recall that from her narrative as well as the police report, yes.
Okay. And then do you also recall a separate incident in which she called the police because Mr. Benyamin actually left with her child and took off with her?
Yes, I think I may not have been clear that that was in Asheville, but I do recall that incident as well. I think I may have presumed that that was at the location where her mother was residing, that
Okay.
call was placed.
And I'm not going to hold you to what's in those reports. We've actually heard testimony of witnesses that were there when those incidents happened. So, but you did review those?
Yes.
Okay. The cell phone searches that you reviewed, well, let me back up. The medical records that you reviewed, you don't find any dispute or disagreement with the medical records that indicated that Ms. Driver was suffering from delusions while she was in the hospital, do you?
That is correct. I think I cited in my report that I believed the sources of information that were presented over time to be highly consistent.
And she was also, I think, reporting some hallucinations while she was still in the hospital as well. Is that right?
I think that it was noted in the mental health records. I can't recall if they clearly articulated what those were, but I do recall that being noted in the mental health records from the hospital.
Okay. Those reports of delusions and hallucinations were consistent with other collateral sources that you had regarding Ms. Driver's state of mind leading up to this incident December 8th, right?
That is correct.
Reports from the other individuals that were interviewed were all reporting her state of mind or a destabilization of her mental state. Is that fair?
Correct.
And I think you also reviewed an audio recording that Mr. Benyamin had that he had provided to law enforcement, on which she was talking about these delusions that she was experiencing, right?
Correct.
So it's clear, based on your review of the records, that Ms. Driver was absolutely going through stages of paranoia, experiencing delusions, and dealing with hallucinations in this build up to December 8th.
That is correct.
Okay. The cell phone searches, particularly, there are a couple of specific searches that she conducted, actually looking up the definition or the idea of schizophrenia. Is that right?
I recall the mention of schizophrenia. I would have to look at my report to know if she was looking up to see what it meant, but I do recall the mention of schizophrenia in one of her searches, correct?
Page 11 of your report, I think, Dr. Zom, indicates the cell phone searches.
Yeah, I think it's just the word schizophrenia.
Okay. And she did that on 2 different days, correct?
That is correct.
Okay. And she also looked up topics such as the whole world is programming me, correct?
Correct.
And she looked up on November 11th mental institutions in Knoxville, Tennessee.
Correct.
Now, were you aware her parents lived in Knoxville?
I was.
Okay. So is that possibly something she was looking at in order to try to get help for the issues she was dealing with?
It seems so, and she mentioned multiple times that she had tried to get help and had asked for help.
Yeah, she was telling Mr. Benyamin and the 2 other wives and the other people that she was around that she needed help for the issues that she was going through, right?
That is correct.
And you understood that this religious philosophy that Mr. Benyamin had was to exclude the access to traditional medical treatment, right?
That was my understanding.
I guess I should say modern day medical treatment, not traditional medical treatment, right?
That is my understanding.
He did not want Ms. Driver to be in a hospital, right?
That is my understanding.
In fact, he didn't even want Ms. Driver in a hospital when their child was born, right?
That was my understanding based on what she reported.
He did not want her to be institutionalized in any way, shape, or form, right?
That was certainly my understanding.
And he certainly didn't want her to be on any pharmaceutical drugs.
That was my understanding as well.
And she was telling you that because he didn't want her breastfeeding their child with medicine flowing through her body, right?
I don't know if that was stated as the reason that he didn't want that. My perception was that it seemed to be more so consistent with his overall beliefs. I don't recall it being specifically from his rationale about the breastfeeding. I do recall her mentioning having some concerns about what she would ingest in breastfeeding, but I believe my perception was that him not wanting her to have medication was part of his overall philosophy of how this group of people should engage with the world. And
it was clear to you also that she, in a sense, was somewhat rejecting that idea of his philosophy, right? Because
it did seem certainly that she had started to reject his philosophy.
Even back to when the baby was born, she did not want to leave the hospital that quickly after the birth of the baby. Is that right?
That was my perception based on what she stated, yes.
She had indicated previous to the child's birth that she thought that they needed to be seeking prenatal care for the child, right?
That was my understanding.
And particularly in this instance, she was searching for mental health institutions. She was searching for schizophrenia as a way to understand what she was going through. Is that fair?
I don't believe I asked her exactly why she was researching schizophrenia, but I certainly would not dispute that.
Your medical opinion as a psychologist someone that is suffering from paranoia and delusions and hallucinations, those are all symptoms that are consistent with somebody that could be diagnosed with schizophrenia. Is that fair?
With a psychotic disorder, yes.
Yeah. The other two evaluators in this case, Dr. Ballard and Dr. Garrett, do you know either of them?
I don't know them. I did listen to their testimony, but I do not know them prior to this hearing.
And you're aware, based on listening to their testimony, I know you didn't read their reports, but listening to their testimony, they both diagnosed Ms. Driver with schizoaffective disorder, bipolar, correct?
Yes.
And borderline personality disorder, right?
Correct.
Do you have any issues or take any issues with those diagnoses that they made?
I do not take issues with those diagnosis. I think it was clear from the history that she likely meets criteria for borderline personality disorder, as well as there are both mood symptoms and psychotic symptoms, which is captured by the diagnosis of schizoaffective disorder, but could also be captured by other diagnoses. But yes, mood symptoms and psychotic symptoms are part of the clinical picture. Okay.
Yeah, you testified that there's a difference of opinion about whether or not in a forensic setting you should make a diagnosis.
Correct.
And I grant you that. You don't have any concern that Dr. Ballard and Dr. Garrett both made that.
No.
What you said you were considering some diagnoses. What were those diagnoses?
Borderline personality disorder and bipolar disorder with psychotic features, or an unspecified psychotic disorder. I am very reluctant to diagnose schizoaffective disorder only because the particulars of that diagnosis, the minutiae details, are very difficult to capture from someone's self-report alone. So I'm very reluctant to assign that diagnosis if I didn't observe it within an inpatient setting.
Okay. Is it fair to say that you're conducting this evaluation some 3.5 years after the incident would also affect your ability to make a specific diagnosis of her in terms of her symptoms that she was exhibiting at the time that this happened?
I think she was incredibly vivid in describing her symptoms, and the mental health records are voluminous. So I wouldn't have necessarily had concerns about assigning a diagnosis for that reason.
Okay. But at the end of the day, your diagnosis is pretty close to Dr. Garrett and Dr. Ballard.
That is correct.
All right. How long was your interview with Ms. Driver?
I believe that it was around 3 hours.
Okay. And it was on one day, correct?
It was.
When you met with her, she reported at the time that she had been on medication at the jail for some time, right?
Correct.
And I think in talking to you outside, you did indicate that you don't believe you received any jail medical records.
I don't believe that I received mental health records from the jail.
Okay. So you don't know specifically what medications she had been on while she was out there, other than what she reported to you?
So I know what she reported to me. She also was articulate in, I believe, stating what she previously was prescribed, and I believe that is noted within my report. It was also noted on some of the hospital records what she was prescribed at the time of discharge. I will say that I don't speak to the specifics of what medications are prescribed for. Even though a Google search may say they're prescribed for one thing, I believe that should be left to the psychiatrists and the medical treatment providers. I'm not a prescribing physician, and my experience is that most medications are prescribed for different things. Even though they may primarily be used to treat one thing, they're also used to treat other things. So I would defer any questions about medication.
But at the time you interviewed her, your belief was that she had been on medication for some time.
Correct.
And that she seemed to be fairly stable on that medication.
She did note that she had been taken off one medication and that she had experienced an increase in some symptoms, not psychotic symptoms. It seems she had gotten into a fight, and that was out of character for her. So she had been on some medication for a very long time, but it seemed that medication had been changed.
Okay. But as far as it related to her psychotic symptoms, such as the delusions and hallucinations. The medication that she was on had been addressing those.
That was my belief, yes.
Okay. And that is how you perceived her when you were interviewed?
Yes.
Her, right?
She did not seem psychotic when I interviewed her.
Okay. Dr. Zom, someone like Miss Driver that had exhibited the symptoms that she, as you talked about, was clearly showing to others, the paranoia, the delusions, the hallucinations, before this incident. If someone is experiencing those things and is not getting treatment, is it fair to say that her condition will continue to worsen?
It's certainly expected in most cases that someone who is experiencing psychotic symptoms will continue to deteriorate in the absence of medication.
Is it also fair to say that someone that is not being treated for those illnesses and experiencing those symptoms, those delusions that she is hearing and receiving, it is going to grow harder and harder for her to not succumb to those?
So mental health symptoms, psychotic symptoms can be transient. They can come and go. They can worsen and lessen in severity. However, she was also in a stressful situation. So yes, it would be highly unlikely that her condition would spontaneously improve in the absence of treatment or removal of a stressor.
And it's clear from some of her cell phone searches that she was having these delusions about killing herself. She was actually searching things to kill someone, right?
Yes.
Now, there's no indication that she was searching to kill herself or someone else, just searching to kill some person, correct?
I believe so.
Okay. And she was searching for other things as well in a manner to basically extricate herself from the environment that she was in.
Correct.
Even on the December 8th, where she was searching for a bus ticket.
Correct.
For her child, right?
Correct.
Okay. Now, let me talk to you about delusions to kill somebody. If I'm suffering a delusion that I need to kill the judge, and the judge knows I know her very well, I think she's a great judge, so that would clearly be a delusion in our sense. But hypothetically, if I'm suffering from a delusion and that delusion is telling me that I have to kill her for whatever reason that is it common that in that delusional state I would search for a weapon?
It's not uncommon.
It would be consistent with my thinking in that delusional state that if I have to kill her, I have to do something to do that, correct?
Correct. I
have to find a weapon, a gun, a knife, some type of object for which I can carry out my plan, correct?
It's not unexpected.
Right. So if I did not have a weapon, I might search around for one, right? Like I might look, where's a weapon in this room that I can grab? What can I do with it, right?
Certainly.
But that's being done in that delusional state because I'm not capable at that point in time of thinking that, whoa, this isn't the right move, right? I'm delusional.
I'm not sure I understand your question.
Well, a delusion is a fixed false belief in an idea, right?
Correct.
So if I have a fixed false belief that I have to carry out a plan to kill somebody, my mentality is going to tell me do whatever it takes for me to carry out that goal, right?
That is correct. I do think it's important to state that while she was suffering from delusions, her delusions were not as fixed as they are in some situations, which is also apparent in her internet searches. She's going back and forth between questioning the ideas of what she's being taught, questioning her own ideas, trying to look for a bus ticket to escape her situation while also looking up ways to kill someone. So yes, delusional, yes, she was suffering from delusions, not as entirely fixed as we do see in some situations.
But those situations, as far as how fixed or how severe those delusions are going to change over time, right?
For many people, they do. For someone with a purely delusional disorder, they may not. But for someone with her what we believe to be her diagnosis, yes, we would expect her symptoms to fluctuate over time.
Between sanity and insanity, and I know that's
And it's a spectrum of varying degrees.
And she told you that on December the 8th, they woke up and went to a 12 Tribes meeting that morning, correct?
Correct.
And she told you that at that 12 Tribes meeting, they talked about death, and she interpreted that discussion about death as a delusional reference to her that she needed to kill herself.
I do believe I recall her talking about the meaning she assigned to the 12 tribes, of perceiving that to be a message to her that she needed to kill herself, that she needed to do it.
And she took that message, in her mind, she took that message as, this has got to be the day that this happens, at the time, right?
That seems correct with what she told me, yes.
And when they got to Canton that day, around lunchtime, she was forced to go up into a room by herself, is that right?
That is correct.
And she was forced to be in that room even though she was telling Mr. Benyamin she did not want to be alone.
That is what she reported, yes.
Because of what she had already been experiencing that
That
day,
is
right?
correct.
She took the sign of being by herself in that room alone again as an additional signal that she needed to kill herself.
Correct.
Right? And then ultimately she told you that the final straw, as it were, was getting this dirty shirt sent up to her, right?
Correct.
And she interpreted that dirty shirt as the last signal to her that she was not capable of living. She and her child were not capable of living, right?
Yes, I don't think those were her exact words, capable, but yes, she took it to mean that they weren't worth anything.
It was consistent with her delusions that she had been experiencing that entire day, beginning that morning they woke up, right?
Correct.
And it was at that point where she got the shirt that she went downstairs to get this knife, right?
I believe that is correct.
One second, Judge.
Ms. Gropper, any further questions of this witness?
Just briefly. A moment ago, you said that she took the dirty shirt to mean that they weren't worth anything. So her viewpoint of why she carried out the act at that moment, as she expressed to you, was that in that moment she felt like her and Hannah were worthless.
I would have to go back and read my words to know directly, but I recall her saying when she got the shirt, it meant that it was her language if they weren't worth anything. I don't know if I took that to mean that they were worthless.
All right. And you indicated that Miss Driver's delusions were not as fixed as some.
Right.
She had significant periods of lucidity and stability and ability to engage with the world around her.
Yes, someone with a diagnosis of a delusional disorder has very fixed delusions that do not fluctuate over time and are impossible to challenge. The nature of her mental illness was such that she was fluctuating and questioning different sets of beliefs at different times.
Okay. And some of those questioning sets of beliefs may have been related to her religious ideological views?
Yes.
Okay. And some of it may have been related to her mental health?
Correct. She articulated times at which she questioned her own mental health symptoms.
Okay. And Mr. Kessler asked you about, that she was begging these people for help and that they weren't giving it to her. Did she indicate to you at all when her and Hannah went and spent 2 days with her mother just prior to the murder whether or not she sought out treatment or assistance from her parents?
I don't recall if she articulated the particulars of seeking out treatment. I do recall that she stated that while she was there, she then started to become paranoid of her parents. and of the things that were going on around her.
Okay. And you indicated that you had reviewed some jail communication prior to your evaluation of her.
Correct.
Were you at any time aware of anyone communicating to Ms. Driver that if she acted normal in your evaluation, she would be screwing herself?
I am.
Okay. And who was that?
Her father.
I have nothing further. Thank you.
Anything else of this witness? All right, thank you, Ben. You may be excused. All right, we are going to take a recess at this time. We're going to let you be in recess until 1:45. Leave us your notepads. Don't talk to each other. Be back in the jury room at 11:15, 10:45. Members of the jury, the state has rebuttal evidence that it is going to present at this time.
We call Deanna Jarrett. Can you raise your right hand? Do you solemnly swear or affirm the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you state your name?
Deanna Jarrett.
Right. Ms. Jarrett, you'd previously testified that part of your responsibilities at the District Attorney's Office is reviewing jail calls and jail communication.
Yes, ma'am.
All right. Your Honor, at this time I would tender States Exhibit 134 and 135 by agreement of the parties.
No objection.
States 134 and 135 are admitted.
Okay. Are you familiar with what is represented in States 134 and 135?
Yes, ma'am, I am.
And what are those?
They're jail calls that Chloe Driver made to her mother, Renee Driver. These calls were made in February of 2021. The first call was February the 21st of 2021, and the second call was February the 23rd of 2021.
Okay. Your Honor, I'm publishing States Exhibit 134, which is the February 21st, 2021 call.
Thank you. Please remain on the line. Hold for acceptance. This is a prepaid call from
Chloe Driver.
an inmate at the Cherokee County Jail, Georgia, carried by Consolidated Telecom. Three-way or call waiting is not allowed and may automatically disconnect this call. This call is subject to monitoring and recording. If you are an attorney or designated legal counsel, contact inmatesales.com at 702-931-3938 to have your number set to do not record. Please select from the following options if you consent to this call being recorded, and to accept this call, dial 1 now. To reject this call, your call has been accepted. Chloe?
Yeah.
Hey, I saw the 386 number. And I'm like, I'm not going to answer that.
Yeah, it does this weird thing. Like, it's gonna, what's it called? Like, mirror your number. Like, if I call anybody, it's gonna mirror your number. I don't know why it does that. But it's
Okay. Because I called twice, and I'm like, who do I know in Florida that's in jail? I'm like, I might be other jailbirds are right here in the south.
right. Well,
So I don't look at Tyler here, and I'm like, well, I don't need to answer those calls, because I don't need to know, you know. But now if I know it's you, I'll answer.
right. Yeah.
Well, how do you feel? I assume you're in regular.
Yeah, I'm in medical. They moved me. I have a roommate. It's been really good.
Okay, just be careful of what you say.
Yeah.
And are you more comfortable over there, or you have a, like, you can go,
But they're going to move us to a quieter part, I think. They're going to move us to a quieter part medical.
I still don't understand what medical is. I don't get why you're not in, whatever, I don't know.
I don't know either. It's just whatever. I don't know. I know if I ask, they can like look into it for me, but right now I'm okay where I'm at. Like my roommate, I'm really struggling at the moment, so.
Okay. You get, okay, on snacks and books?
Yeah, I mean, I would like, if you could add like 500. And just keep, like 500, because I put all my money on the phone, like 100 left. I put it onto the phone. It's expensive calling. Yeah, if you could.
Wow, so you could possibly set up for, that's a lot of money that you're spending on writing.
It's like $3 for 15. It's like $3 to $4 for 15 minutes.
So you've been calling quite a bit?
No, I just within the last, not really. I mean, I'm saying I have $100 left from the 200 that you put on. But now I'm asking for fire funding to be put on, because, you know, we said.
So you can call Brian. Okay. So you can call Brian.
I did call him, we talked, and is Dad able to meet with him in like Waynesville or Silva
Nope.
tomorrow
For what?
for the money?
Chloe, Dad? No. No. I'm not gonna do it. His dad is yours and you're gonna get it for the rest, for however long you're in jail.
What?
That money is for you to eat and to survive on.
And he's going,
For how?
he's gonna give me the money too, like he said he will, like, it's,
No, you won't. No, you won't. You're gonna be dropped out of his life the next year. I promise you.
fine, we can do
What?
we have.
The money is not even available right now. His dad he's invested.
Invested in what? I never said that would happen. I said that he could do whatever he said that was like when he was gonna like make he was gonna invest like a couple of hundred or something in something. But
He doesn't have the money he doesn't have it to get right away.
can you explain that?
I just did, he invested it.
In what?
I don't know. You have to talk to Dad about it. You have to start calling his phone number.
Well, I tried to call him, he didn't answer.
Oh, he might be sleeping.
So you're telling me there's no way to get? I think you're lying. Are you sure about that? Like, there's really no way to get.
I believe me, Chloe, I'm not lying to you. I have no reason to lie to you.
Huh?
I have no reason to lie to you. We were trying to make a future
You want
for
to
you
keep the
and
money?
Hannah. So we were trying to make a future for you and Hannah. And some of it was invested, and when all this happened, he went ahead and invested all of it. I mean, he can get it, but it's not going to be.
Can he speak with Brian? Can they set up communications with each other? Can you please have Dad talk to him? Because Brian said that Dad promised to call him, and he hasn't done it yet.
Yeah, that is strong. Call anybody.
Okay.
Brian Leonard decides to throw these little words in. How we promised this, or how he promises that, or I refuse an animal, or whatever. He doesn't tell us the truth, guys.
Well, he said he didn't have the uniform when you asked for it, and his dad asked for it, but he has the uniform now.
Sorry, but it's not worth $65,000. Or whatever it was. And you're silly. I'm telling you, Chloe, you're going to lose your family if you go this route. And if you're okay with that, then so be it.
No, I feel like when things settle down, everything will be okay again. But, I mean, when it's all heated right now.
Well, you are not thinking clearly, because giving him that money, you'll never see anything again. You'll never see any of it again.
Say such cruel things about him, like it's not. Please don't do that.
Chloe, he's moving on after this is over. I wish you realize that. He's moving on to his next victims. The next young children he can brainwash.
Children, really long.
Oh, were you 16 when you met?
Okay, guys,
Well, you were a teenager, Chloe.
huh?
Anyway.
Mom, you can't stay mad at him for this. You can't. I know you
I
want
can't say that. I'm going to destroy my family's life.
I did.
I can't.
I decided.
No, we both did that.
Really? Because all he ever did was try to fix our family. Like, remember? Like, she was saying,
So stop.
What do you mean?
Stop.
Okay, that is true. I just
Your father and I have never needed fixing. So I don't even know what you mean by that.
emotionally, we were very, what do you mean? Everyone?
No, I mean, emotionally, you had your problems, and you never shared them with us. So, you know what, fine.
I think I could.
Well,
But then he taught me how to
you found a 40-year-old man at age 16 to share your issues with. Good for you. And look where you're at.
Well, can you move the money?
I'll talk to Dad.
Can Dad?
You need to go through Angela about all this instead of something on and on a recorded phone call.
It's okay. It's okay to move. Okay, all right.
This thing's looking your way, Chloe.
It would, Mom, it would be okay if you just told Dad to speak with him. Then it wouldn't be anybody.
I'm not telling your father anything. Your dad's blocking for a reason.
Mom, you can't just steal my money.
Oh.
Mom, that's what you're doing.
Is that what you think I'm doing?
No, I think that's what you're doing if you don't listen. Please don't do this. Don't make a war between us. Like, I'm asking you to do something with my money. Can you please listen?
Chloe, the only person that made a war between us is you. I haven't touched your money, and nor do I want to touch that money.
Okay, Mom, then can you please have Dad unblock?
Again, I will talk to him, and I will talk to Angela. Or you can talk to Angela.
Well, all we need to do is just tell
And
Dad.
believe me, Chloe, I don't want a penny from you. You took everything away from me that ever mattered from you.
I'm glad that we're
So
on.
don't ever accuse me of stealing any money.
No.
See, you don't understand what we're going through. You really don't.
I know you're not trying to steal my money, but you're trying to rule over me like I'm a 5-year-old, and it's not okay. You give the money to them. That is
Chloe,
not okay.
somebody should have taken over somebody should have treated you like a 5-year-old 5 years ago, so you would have never been in this mess today.
Yeah, you should have, and I wouldn't have been in the situation, but you never cared to.
Look, are you kidding me? Is it my fault?
I know you're right.
Ms. Jarrett, you indicated that was on February 21st of 2021?
Yes, ma'am.
Okay, and the next call was on what date?
February the 23rd of 2021.
Okay. Publishing States Exhibit 135.
Thank you. Please remain on the line. Hold for acceptance. This is a prepaid call from
Chloe Driver.
an inmate at the Cherokee County Jail, Georgia, carried by Consolidated Telecom. Three-way or call waiting is not allowed and may automatically disconnect this call. This call is subject to monitoring and recording. If you are an attorney or designated legal counsel, contact inmatesales.com at 702-931-3938 to have your number set to do not record. Please select from the following options if you consent to this call being recorded, and to accept this call, dial 1 now. To reject this call, your call has been accepted. Hello?
Hey.
Hello?
Hi. Can you hear me?
Oh, yeah. What's up?
Hear me now?
Yes.
I saw Angie today. I didn't get my September. She came and saw me, so now I'm on my free time. And, yeah, I don't know. Did she tell you that I was going to call?
She said you were going to try to call, but, I mean, it is what it is. I didn't know if I was going to hear from you or not.
Well, just for future reference, you you can hit number, you can push 1 to accept the call.
I know that now. I know that.
Okay. Yeah. So we first answer. Well, I talked to her, and I guess you'll be happy to know that they blocked him. I can't call him, so. And I'm not going to be talking to him. They blocked the number.
Only because you're being forced not to talk to him, right?
I mean, basically, yeah. What do you want me to stop?
But you still don't understand, do you?
Well, I'm not going to pursue it.
I mean, the things you said to me, the things that you said to me the other day when we talked was just, it was just hateful.
When I said,
And I can't.
when I was saying
What?
you stole, when I'm saying like stealing money, like when you had said the investment thing, that's what, because I didn't say, like I didn't know anything about that, but now I understand what you were saying, and I actually appreciate it.
It's just a different account. It's not something that, well, it doesn't matter because it's not happening. I refuse.
Confused what?
I'm either going to give it to charity or the government before I give it to him.
Okay, I mean, I'm not, like I said, I can't pursue it anymore, you know, I'm not going to, if I was free to do that, I was going to pursue it, but I mean, like, they're kind of making it to where,
I do not want to talk about that. I do not want to talk about the money anymore. I am sensitive to this money. It's been nothing but a curse. I wish it was never in my account to manage. If I would have known this was going to happen, I would have never accepted the money. It's nothing but a headache. I don't want a penny of it. I never have, never will. And as far as the other thing that you said was pretty hateful, I mean, it's not my fault that it's not my fault that you're going through this. And I was not attacking neither to any of you.
I don't know where you're getting all this from, but we should like just stop talking.
Because you told me I should have been more strict. When I said I should have been more strict, you said yes. Then maybe this wouldn't have happened. But Chloe, I don't think you remember how you were as a teenager.
No,
You never listened to you never listened to me. Just like now, you still don't listen to me. I can tell you what's best for you, and you'll just argue with me because it's not what you want. And the fact of the matter is I've got 30 years on you. Okay, you're 20 years old, and you're inexperienced, and you just are going with the first thing that you go, the first person that you met with, or met. That happened to be twice your age, or more. Which means he's got plenty of life experience, way more than you will, or that you have. So, I also have way more life experience than you. And I really wish, just once in a while, you would actually take my advice. But if you choose you don't want to take my advice, that's fine. Then there's really no reason for you to call.
Okay, then can you move all the money back into my, okay, so if I'm talking
No.
to you and I have to know how much was to get what I need from commissary, how much was to get if I don't talk to either of you.
Dad and I are going to start putting money on your account. It's going to be a lot less than what you're used to.
Oh, you're going to start trading?
You've got money on there right now. You've got probably, I think, about $200 on there. That will last you quite a while.
I have, and I moved half of it to my phone, so I only have 127 on it, and I moved, there's 50 of it, actually about 40 now, on my phone, and I can't move it back, so.
Okay, well, your father just put another 100 on it yesterday.
Okay.
So whatever's on your commissary, you can check it. You just need to spend it wisely. Okay?
And start doing, like, you're just going to start doing it weekly?
No, we're going to watch and see when you're going down, or you can give me a call, or you can give your father a call.
But you're making it sound like you don't want me to do that.
Well, Chloe, you probably need to manage this money. You can call us once a week if you need anything. You can call once a week if you need anything. If you want to talk and be civil, you can call us twice a week. I don't care. But the point is you haven't been, since you've been starting to talk to him, you've changed right back to the old Chloe that was before any of this even happened. Stubborn, he knows everything, nobody else knows anything, type of person. And I don't want to deal with that Chloe. I want to deal with the Chloe that
I would like to just...
you were before you started talking to him again.
Well, to me, that started talking for that me before was doing a lot of drugs. So, I mean, he
What kind of drugs?
I was like, what do you mean? Like,
I'm talking about a month ago when you weren't talking to him, you were civil. What are you talking about drugs? What do you mean?
I thought you meant from way back.
No, Chloe, you have, oh my God. You're such a sensitive little girl.
Okay, I just want to wrap up.
Are you still taking your medicine?
Yes,
That they're giving you? Well, maybe you need something stronger.
that's really fucked up for you to say that to me.
Don't talk to me that way, and you know it's not.
You're being really rude.
Really? Don't talk to me like that. No, I'm not. I'm speaking the truth.
No, you think you're speaking like that's... It's still for you to say you're not qualified to say that. Are you a doctor? Do you want me to start with...
What else do you need, Chloe? What else?
You agreed, because of the funeral, you agreed to give $5,000. And I think that's fair. Because of the...
Well, you know what though? I just found out the state of Georgia will reimburse him. And I agreed to that before I talked to Dad. Dad doesn't want to touch that money.
But
Other than giving you the money that you need. Because it's not your own money, yeah, we have to deal with it.
no, I heard what she told me today. She was making it sound like she was scaring you into not touching it.
Sharon, who?
You
Who are you talking about?
tell Angela to not touch that money.
No, because she didn't scare me into not touching it.
Huh?
No, she didn't scare me into not touching it.
Okay, well, I mean, she told me that she told you that.
Okay.
And it sounds like you're listening to her by saying that you're trying not to touch the money. You're trying not to have anything to do with it.
Well, I already told you I don't even want to talk about it.
Well, that's what I'm saying. If you can wrap up this conversation. So you know for a fact, Mom, that he's going to be reimbursed for that? Because if he's not, I was like...
That according to, yes, I heard that from Angela. That there's a victim advocate or something to do with funeral. I mean, it's been a while since she told me, so I can't really remember what she said word for word, but...
Okay, then I'll talk with her, and if I get confirmation that's the case, that can be the last that we talk about the money, because I don't want to talk about
Okay,
it.
that's all I want to hear about. That's what I want to hear.
But
You're not going to go without.
Okay.
You might not go without, okay?
All right, if that confirmation doesn't come, though, I want to have the 5. That's only if she doesn't know for sure she's going to get that. But, so...
Well, I'm sure there's a process he has to go through. It just doesn't get mailed to him. I mean, he's going to probably have to show how much it costs or whatever. And I'm sure there's I'm sure there's a limit or whatever. But I don't know. I have no idea. I've never went through all that. I don't know.
Well, that's the only thing I'm going to be talking about, if something else
It's all bad. I just don't want to talk about it because I don't care about it.
Okay, well, it's just one little thing. Like, it's just that one thing. If, then, that, you know?
Chloe, I really feel like you're being very disrespectful with your tone and your words and you swearing. I really do. You put this family through a lot, and somehow you're being bitchy to me.
Because of what happened yesterday, I think it's what?
What happened yesterday? I didn't even talk to you yesterday. You called me 3 times and I didn't answer.
Okay, sorry, the day before. Time's a little funky here.
Mm-hmm. When you were very rude.
When you were telling me what you were going to do with my money, I felt like that was rude, and I told
Enough, Chloe. You're going to be taken care of, whether it comes out of your money, or whether it comes out of that loan, or whether it comes out of my money, okay? You'll be taken care of. But stop making it sound like it's your money to where you're controlling me. This is not happening that way.
I just want to know where my money's at and what's happening with my money.
Your money is in a different account.
Okay.
That's all I know. Dad put it away. I don't talk to him about it. He doesn't talk to me about it. The only time this ever comes up is when you are on the phone. Like I said, we're going to lower your budget and we'll take care of it. Just got to be very, very careful on how you spend, because I'm not going to be putting $200 and $500 down on your account like you were asking. I'm not doing that.
Okay, well, you thought to do that just a few weeks ago. You thought that was a great idea to do.
I told you this call will be terminated in 2 minutes. Chloe,
What?
I told you they charge 10%. You're the one that said put more. Dad doesn't want to, and we're not going to.
Fine, I'm just saying. So when I need books,
Then you give me a call. We'll see how much they are, and we'll go from there.
you can go on like cheap, and there's something called.
I know.
Like,
I know. We will. But you really need to be managing your commissary money.
well,
You
it's not
know.
that you're not for me.
Fine.
You're the one in control of it. It sounds like you're going to be doing that for me.
Talk about when you order your food.
Well, I skipped it a couple of times.
This call will be terminated in 1 minute.
I get that, Chloe. I get that. I'm just saying, just please start watching and paying attention. And you've done good so far, except for the phone calls. I think you're spending way too much money on phone calls. But I think that's about to be over.
Well, one, yeah, it's about to be over. Two, it's because I called during the weekend, and weekends are more expensive on patrol. That's all.
Okay. Okay. Well, just call during the week, okay?
So, yeah, I will. Well, now that I know that, and this is probably going to hang up, so I'll call back and then, I'll call back again. Because,
Okay.
so I'm almost done with my Game of Thrones.
Mm-hmm.
Like my barbecue grease. She really likes it too. Since I'm almost about to be done with that, I'm thinking about.
This call was terminated because it exceeded.
I don't have any further questions.
I don't have any questions at this witness.
All right, you can step down. Thank you. Any other evidence from the state?
None from the defense, thank you.
All right, members of the jury, then that concludes the presentation of evidence in this case. we have some matters that we are going to need to discuss before, outside your presence, before we move on to the next phase of the trial, which will be the attorney's closing arguments. I know you ordered lunch. It probably isn't here yet. I am going to let you be in recess until 1 o'clock. If the lunch isn't here yet, certainly feel free to step outside and make calls, whatever you'd like to do during your lunch recess. But we will see you back in the jury room at 1 o'clock. Thank you. The attorneys now have the opportunity to come to you with closing arguments. The state has the right to open and conclude.
I told you when I stood up before you in opening statements that Hannah would get lost this week. That there would be a lot of shiny objects, there would be a lot of scandalous evidence, there would be a lot about Chloe Driver, the cult they were in, Benjamin, his abusive, controlling practices. And all of a sudden, just like that, we forget why you were all here. This is why. You will have an indictment, and the indictment is not about Chloe Driver being a victim. It is about Hannah being murdered by the one person she should have been able to count on to do anything to protect her. There were issues in this case that are relevant to her mental state, to her state of mind, but they are not the focus of this case. The focus of this case is your decision with regard to the counts of the indictment. And the counts in the indictment are malice murder, felony murder, aggravated assault, and cruelty to children in the first degree. And what I want to do with you, I get to talk to you twice. I get to open and I get to conclude because the state has the burden of proof in this case. So what I would like to do is spend the first portion of me speaking to you about the law that governs your decision. And I stood before you in opening statements and I said, now's not the appropriate time for me to talk to you about the law, but that will come. And I have tried to give you glimpses throughout the course of this trial by asking the right questions for you to understand what issues you need to pay attention to as it relates to the law. And this is the part where hopefully it all comes together and we can talk about applying the law to the facts. So I'm going to spend my first portion with you just talking about the law. And then after the defense delivers their closing argument, then I will talk to you about how we apply the law to the facts in this case. The state has the burden of proving her guilt beyond a reasonable doubt. And everybody has heard that term, but very few people really understand what it means. But what it is the doubt of a fair-minded, impartial juror honestly seeking the truth. And when the judge reads you the law, you're going to hear embedded in the law at multiple points is that word truth. And what you will see is that a jury trial and your role is about a pursuit of the truth. And the law gives you tools to find it. And what the law says about proof beyond a reasonable doubt is that that is based upon common sense and reason. You are allowed to bring your life experience and your common sense and your reason into that jury deliberation room with you to reach conclusions, to make deductions, to discard stuff that doesn't make sense to you. You are allowed to do that. And the law expressly tells you that you can. What is evidence? The judge is going to talk to you about the different kinds of evidence. There's two kinds of evidence, and you don't really need to worry too much about the distinction between the two because the weight you give them can be the same. But direct evidence is something that somebody saw, like an eyewitness, something that points directly to a fact. We hear a lot about circumstantial evidence, and it gets kind of a bad rap because it seems like it's less valuable. But really what circumstantial evidence is a set of facts or things that prove something by inference. And I'll give you an example of some circumstantial evidence in this case that we saw. She had cash in her bag. She had a cell phone right there beside her. Those things lead to the inference that she had other options. You can infer, if you wish to do so, that she could have just called 911, that she could have just called an Uber, that she could have just walked out and ran to the neighbor's house next door. You can look at all of the connected surrounding circumstances and you can reach conclusions and make deductions based upon that evidence. You determine the weight to give to the evidence, whether it is direct or circumstantial. That is solely your responsibility as jurors. Now, the judge is also going to tell you that your role is to assess the credibility of the witnesses. And you can consider a lot of things when you're determining the credibility of each witness. And this applies to the statements of the defendant as well, Chloe Driver. You can discard whatever it is you want about the statements she made to the expert, the statements she made in the hospital, and you can accept whatever it is you want. You and you alone are the determiners of the credibility of each statement in this case. And the law gives you tools to decide and assess things that you would normally do in your life just based upon common sense. You know, do these people have a reason to lie? Do they have a motive to lie? Do they have anything to gain from the outcome of this case? Things that you use in your everyday life to assess people's credibility, you can do in this case as well. And the judge is going to instruct you that this is the law, the nature of the facts about which they testify, their means and opportunity of knowing the facts about which they testify. And this is true for expert witnesses as well. And I think that that's an important distinction for you to understand, is that just because somebody comes in here and they're called an expert doesn't mean that you have to automatically accept their testimony or their statement or their conclusions. We saw this week that there were multiple experts, and they had varying degrees of thoroughness with regard to what they chose to focus on, with regard to what they assigned weight and significance to. And you can accept or reject any testimony of any expert that came before you this week, just the same as you can with any other witness. The person in this case who has the most to gain is Chloe Driver. And that is clear. We heard evidence from the experts about sort of the cautionary tale that is using the DSM-5 in a forensic setting, because the people in a forensic setting necessarily are facing criminal charges and necessarily have reason to kind of exaggerate their symptoms, because there are defenses under the law that only apply to them if certain things exist. So that's something that you can evaluate in deciding how much credibility and weight to give to the statements that Chloe Driver made after she had had the opportunity to consult with a lawyer and after she understood what her options were for a defense. And I'm going to go through some of her statements in my second closing that she made before she consulted with a lawyer, before she knew the law on insanity. The truest version of her statements about her motivations and why she did what she did was in that hospital when she was writing. It was closest in time to when she committed the act. What you're going to have to determine is what was her mental state at the time she committed the act. So those statements are valuable both in they are the closest in time as you will ever see to her committing the act. And it was prior to her understanding what her options were to get out of the situation she put herself in. So I ask you to assess that in determining which of her versions of statements to assign the most credibility to. Venue. The judge is going to tell you venue is a jurisdictional fact, and every crime has to be prosecuted in the county in which it occurred. And the reason I think this is important to talk to you about in this particular case is because the only crimes committed in Cherokee County were by Chloe Driver. And what I want you to know is that there has been a lot of collateral information put before you about what happened in Asheville, what happened in other places, people that Benjamin has abused elsewhere, crimes committed by third parties. You, me, the judge, nobody in this courtroom has any power or authority to do anything that happened about anything that happened outside of Cherokee County. And so I ask you to focus on what your role is as a juror in this case. And the only crime that happened in Cherokee County was the murder of Hannah Nicole Driver. And I ask you to focus, because that is your role and your duty and the oath that you have taken to determine what the law and evidence is regarding the commission of that crime. Whether somebody else has committed other terrible crimes in another jurisdiction is not a question that you are going to be asked today. And it is not a question that you have taken an oath to resolve. So you have to focus your attention in on Hannah, the law as it relates to Hannah, and the evidence as it relates to Hannah. The charges in this indictment are laid out: malice murder, felony murder based on the underlying crime of aggravated assault, felony murder based upon the underlying crime of cruelty to children in the first degree, and then the offenses of aggravated assault and cruelty to children in the first degree. You'll have the indictment back with you, so you'll be able to look at the charging document, count 1, count 2, count 3, count 4, count 5, But I want to walk through a little bit about what the state has to prove to establish each of those crimes. The first is malice murder. In order to establish and prove malice murder, the state must show that she caused the death of another human being unlawfully and with malice aforethought. And obviously, I told you in the beginning, there's a lot of words in the English language that people know and use, and then the law assigns them maybe a different meaning. So, we say crazy, we say insane, we say mentally ill, and there are definitions to those things and what they mean under the law. There's also a definition about what malice means. So malice does not mean ill will or hatred. And I think that's important because the defense has spent the week talking about how Chloe loved her child. Nobody has to establish that she didn't love her child. The element of the criminal offense is what her intention was in committing the act. And the intention in committing the act of stabbing that child to death doesn't have to be based on ill will or hatred. It can just be the unlawful intent to kill another person without justification. And what malice can also be is when the circumstances show that the defendant did act with a deliberate intention to end someone's life. And we know she did. That she had malice and that she had every intention for Hannah to die. The next count in the indictment is felony murder. Felony murder is when a person causes the death of another by committing a felony. The distinction here is there doesn't have to be any intention to cause the death. There just has to be intention to commit the act. So if you intend to commit the act and it does cause the death, that is a felony murder as long as the underlying act is a felony. And so what we've charged in the indictment is there's one count of malice murder for maliciously and intentionally killing her. Then you have 2 counts of felony murder, and the felonies alleged in those 2 counts are aggravated assault and cruelty to children in the first degree. So if she commits a felony and that causes the death, that's felony murder. And I'll kind of walk you through the underlying felonies in this case as well. So one of the underlying felonies in the indictment that the felony murder count is predicated upon is cruelty to children in the first degree. Cruelty to children in the first degree is when an individual maliciously causes cruel and excessive physical or mental pain to a child under the age of 18 years. So obviously in this case, we know Hannah suffered cruel and excessive pain. We know that. We saw it. We know she was under the age of 18. And we know that the act that she committed was stabbing her in the neck. So all of these elements have been met. With regard to malice used in this, the judge will define it for you, what it means to maliciously cause a child cruel and excessive mental or physical pain. But again, it's not ill will or hatred. Malice just means an intent to cause the pain without justification or excuse. It means a willful doing of the act with a knowledge that the particular harm may result. She committed the act and she had a knowledge that her death, that her cruel and excessive pain would likely result. That is what the definition of malice is in the context of cruelty to children in the first degree. Aggravated assault. In this case, it alleges that she committed the offense of aggravated assault with a knife. Aggravated assault is when an assault is committed against another person with an offensive weapon. The judge will tell you that an offensive weapon can be a number of things. In this case, obviously, we've alleged it's a knife, but it's any object that is likely to or does cause death or serious injury to another. And we saw the knife, we know that she used it, and we know that it did result in Hannah's death. The legal elements of each of these offenses and the evidence that came before you is very, very clear. And I understand that the bulk of this case as it relates to the law that's going to get challenging for you guys is the defenses, the insanity defense, and some of the things that sort of pertain to that. So I want to talk about that. Under the law, Chloe Driver is presumed sane. Every person is presumed to be of sound mind and discretion. We start from the proposition that she is sane, that she is criminally responsible for her actions, and that she has to suffer the consequences of her crimes just as any other citizen. That is the position you start from. You may infer that the acts of a person of sound mind and discretion are the product of that person's own will. When the judge will give you this law, she will tell you a person of sound mind and discretion intends the natural and probable consequences of their acts. I will talk to you a little bit more about applying this law to what we know about Chloe Driver and her decisions and the actions that she committed, but it was very, very clear that she understood she was murdering Hannah. And she understood the permanency of that decision. She understands that she was taking away life. And the thing about the law is the law recognizes the value of human life, even if Chloe Driver didn't. When we talk about the insanity defense, the state only has the burden of proving the things I just talked to you about. Proving the elements of murder, proving the elements of felony murder, proving the elements of cruelty to children in the first degree, aggravated assault. We have to prove those elements that are contained in the indictment. The defense has the burden of proving her criminal insanity to the extent that she is not criminally responsible. That is not our burden. So that is a difference in the law that is not typical, because usually the state has the burden of proving everything beyond a reasonable doubt. But in this case, because the law presumes she's sane, they have the burden of proving her insanity. You probably noticed in our presentation of evidence, in the state's case, we really just focused on the murder. And in the defense's case, they focused really on the insanity, because that is their burden to raise. It is our burden to focus on the counts and the charges in the indictment before you. You're going to have 4 options on your verdict form. And I think this is important for you to know. It's going to say guilty, not guilty by reason of insanity, or guilty but mentally ill. And I will talk to you a little bit more about what each of these mean as we kind of get into the weeds of it. But this will not be as simple of a verdict form as guilty or not guilty. There are other options. But what I want you to understand is, once all this evidence comes before you and once I really explain to you what the law is, you will really be left with 2 options. Guilty or guilty but mentally ill. Based upon the evidence that has come before you, you will not be able to find her not guilty of committing the act. She has admitted that she murdered Hannah. Not guilty is really not an option, based upon her own admissions about the act. And I want to talk to you about the law of insanity and what they must prove and all the reasons why it cannot and has not been proven and will not, the evidence will not show that the law of insanity applies to her. And we'll talk about that more in my second close. But what I want you to understand is that you still are going to be making decisions. Even if you choose guilt, you will have to make decisions with regard to guilt or guilty but mentally ill. So, when we talk about the insanity defense, I'm eager to get to my second close so we can talk about the evidence and apply this to the evidence, but bear with me here so I can just explain to you the law before we kind of do that equation and put it all together. There are 2 ways of proving insanity under Georgia law. The inability to distinguish between right from wrong and delusional compulsion. And I want to talk to you about each of those. The inability to distinguish between right and wrong. What the law says is the test is whether the insanity was such that it deprived the person of the mental capacity to distinguish between right and wrong in relation to the act. And the judge will tell you that the question that you have to ask with regard to did she have the capacity to distinguish between right and wrong is her mind so impaired that she is incapable of forming the intent to commit the act, or to understand that a certain consequence would likely result from the act. And when we really get into the weeds and we look at it, it is going to be very, very clear based on her statements to the doctors, her actions, her statements on scene, her statements to the detective, her statements to her mother and Benjamin right after she committed the act. She always knew the wrongfulness of the act. She always knew the consequence of the act. That was never lost on her. She never, ever demonstrated any inability to distinguish between right and wrong. She just chose the wrong. And she understood the result and the consequence of that decision. Delusional compulsion is a little bit trickier, and so I want to walk you through it step by step. You have to have all of these things in order to be found not guilty by reason of insanity based on delusional compulsion. And you will see when I go through this, you'll start to kind of put the pieces together about why we questioned all the experts in the manner that we did. Why are they asking everybody if she was afraid of Hannah? Why are they asking everybody if she ever thought Hannah was a threat to them? Because that's the law. And I want to walk you through it piece by piece. In order to show that she is not guilty by reason of insanity based upon her suffering from a delusional compulsion, what they have to prove is that the defendant was actually laboring under a delusion at the time of the commission of the alleged act. That when she stabbed Hannah to death, she was actively laboring under the compulsion of a delusion. That the criminal act itself, her act of killing Hannah, was connected to that particular delusion. You saw me up here ask the expert, I said, tell me the particular delusion. Because what got lost is that we just talk about in her life she's had delusions. That's not the question. And we tried very hard to sort of narrow the scope. I want to know when she was in that room what she was suffering from. I want to know her state of mind at that time, because it is whether she was operating under the compulsion of a delusion at the moment she committed the act, at the time of the crime. There are tons of people in this world who have had delusions or are mentally ill and do not meet the legal definition of insanity. So we need to know, was she suffering from the compulsion of a delusion? What was that particular delusion, and was it connected with the act that she committed? And when we talk about that, it's like if she has a delusion about, there being 169,000 people in the world, what does it have to do with killing Hannah? Those two things are not connected. So there was a lot of religious stuff, a lot of paranoia, a lot of things about, my parents are being watched by the CIA or are the CIA. None of that has anything to do with her motivation and her act of killing Hannah. And that is why in the questioning of all of these experts, I focused very clearly on what were her delusions that related to Hannah. What were her delusions that related to why she killed this baby? That were connected to the victim and connected to the act. Every other delusion, ignore it. It is meaningless under the law. The third prong that has to be present, and this is very important, the delusion has to be to a fact that, if true, would have justified the act committed by the accused. What does that mean? Justification under Georgia law is basically Georgia's self-defense laws. The delusion she was suffering under has to relate to the particular delusion, has to relate to the act she committed, and the delusion has to be as to a fact that if we assumed it was true, it would justify the act or permit her to act in self-defense. I'll give you an example of one that would. If she was in that room with Hannah and she believed that Hannah morphed into a demon right in front of her and was about to kill her, and she picked up the knife and stabbed Hannah in self-defense, that would be a delusion, if true, that would justify the act, because she would have believed she was in immediate danger of receiving death or serious bodily injury from that baby. And under the self-defense laws of the state of Georgia, if we assume that delusion was true, she would be justified in defending herself. That was not the nature of her delusions. None of them. And we asked every single witness, did she ever say anything about being afraid of Hannah? Did she ever say anything about Hannah being a threat to her or anyone else? Did she ever say anything about needing to defend herself against Hannah? Because that third prong of delusional compulsion requires that if we assume the delusion is true, it has to legally justify her acts. She has to be acting in self-defense if we believe whatever is going on in her head. And no matter how crazy the things were that were going on in her head, not a single shred of evidence has come before you that she ever believed Hannah was a threat to her. And we know that regardless of whether she was having delusions in that room or not, she was not acting in defense of herself or others and was not protecting herself or others from that baby. What we know is that what she has told everybody is that she was more motivated by wanting out of the situation or wanting to save Hannah. That is the opposite of justification and self-defense. She didn't view Hannah as a threat at all. And the defense pointed out in this case, well, isn't it true that she was holding the baby's hand in the body cam footage? That's a fact that is helpful to the state because it clearly demonstrates she's not threatened by this baby. She's not afraid of Hannah. Whatever is going on in her mind, she doesn't feel like she has to defend herself against Hannah. Maybe she saw this as a mercy killing. Maybe she was just desperate. But there is absolutely no evidence that this was an act of justification, self-defense, based on what delusion was in her mind. Justification under the law is when she reasonably believed that she had to use that force in order to prevent serious bodily injury or death from Hannah. Or whether she believed that she had to prevent the commission of a forcible felony by this baby. There's no evidence of that. None. She does not meet the definition of criminal insanity based upon delusional compulsion. Because if she was suffering under delusions when she was in that room, the only delusions related to needing to save Hannah, not to Hannah being a threat that would justify her actions under the law. Delusional compulsion does not apply in this case. The judge is going to tell you that your verdict should be a true verdict. It's one more place in the law where the word true comes in. And a trial is about the pursuit of the truth. It is according to the laws and the evidence as you find it to be. But the judge is going to expressly tell you that you are not to show favor or sympathy to any party. The judge is going to expressly tell you you cannot base your verdict on sympathy. And I think it is important to highlight that you have to look at the facts and the evidence and the law objectively, because there are things about Miss Driver that are pretty sympathetic. There are things about the situation that she got herself into that are kind of terrible. But the law does not allow you to make decisions about the outcome of this case because you feel sorry for anyone. The law does not allow you to base your verdict on sympathy. So what I ask of you in that regard is when you go back to the jury room, think, do I feel sorry for her for any particular thing? Take your moment, feel sorry for her, and then set that aside. And instead base your decisions on the objective facts and the law, because you have taken an oath and you have a duty to follow the law, and the law expressly tells you you cannot make your decision based on that. Because every victim of crime deserves that treatment. Hannah deserves that. She deserves the objective and fair application of the law and the objective and fair assessment of the facts. That is the law that governs your decision. Obviously, there's going to be a lot more law, but I tried to highlight the things that I think point most directly to the issues before you. After the defense has their opportunity to close, I'm going to come back before you and I'm going to help you apply that law to the evidence that we heard in this case.
afternoon.
As I told you in the beginning of this case would be difficult to listen to. We also told you from the beginning we had no dispute whatsoever about the facts as to what happened to Hannah Driver on December 8th of 2020. We all agreed that the events that occurred that day are nothing short of a tragedy. Ms. Driver never denied that she didn't harm Hannah Nicole Driver on that day. There's also no dispute that she stabbed herself in the neck over 5 times and once in the chest to try to kill herself. We also told you from the beginning, we're not going to argue about anything related to the facts of this case. This case has always been about Hannah and Chloe's mental state at the time of the crime. That is it. It is clear from the evidence that has been submitted to you that both the state and the defense have shown very clearly Ms. Driver was suffering from severe mental illness at the time of the crime. She was suffering from delusions telling her that she needed to die. There's evidence that she had documented mental health history prior to being involved with Mr. Joyce. There's eyewitness testimony about her condition and the subsequent deterioration in the months leading up to this tragedy. There's evidence that she had been seeking help, communicating to those immediately around her that she was getting worse. And she could not resist those compulsions. She could not distinguish right from wrong. Now, I would agree with the state that they put up a lot of evidence in this case related to Hannah's death. The ER doctor, the medical examiner, crime lab, all of that. All things that we never once disputed. In fact, we spent, I think, 45 minutes one day about listening to the testimony about fingerprints on a knife, but it didn't even have anything to do with this case. There were no fingerprints on the knife. We weren't even disputing the fingerprints or the knife. We've never disputed any of that. We've never disputed cause of death. We've never disputed how law enforcement initially responded to this, or any of the subsequent investigation that occurred in this case. See, in most cases, there's a factual dispute between the state and the defense as to the physical acts involved in a case and the mental intent. Never been an issue at this case. The only question has always been why. It has been about what led us to this deep, dark place. It has always been about Chloe Driver being a young, naive individual with a pre-existing mental health condition that had been previously undiagnosed, mostly based on her age. It has always been about the years of abuse, the coercive control, and living in this cult mentality that exacerbated these mental illnesses. All the experts agree. Ms. Driver was suffering from severe mental illnesses and delusions prior to, leading up to, and on December the 8th of 2020. You also heard from witnesses that described her and had observed that very same behavior well before that day and on that day as well. There's been evidence to show that she was in the throes of a severe mental health crisis during that 2-month period. There has been no evidence presented by anybody that this was an isolated snap or something that she is faking to achieve a particular result. 3 experts told you that. As I told you when I stood here before you in opening statements, I anticipated that they were going to present this case in a manner to draw at your raw initial emotions and hope that you would make those decisions based on those emotions. They presented this case in a manner in which they wanted you to ignore the evidence regarding her mental illness, her abuse, and all of the players involved in this case, and the realities of what goes on in that cult. They tried to paint this picture that this was just a group of wacky individuals with weird religious beliefs, that they were a peaceful, loving, polygamous family with some wacky religious beliefs. Not the case at all. Jason Spillers gave you a peek into their belief system. After over a week's worth of evidence, it is clear that everyone in law enforcement, everyone, including law enforcement, the experts, medical staff, people who were around her, and even the strangers that encountered Ms. Driver during this time, there is overwhelming evidence that she was severely mentally ill. We have given you several examples of documented red flag events that occurred prior to that date that set the scene for what ultimately happened. Think about the incident involving Sandra Torres. Think about when Benjamin took Hannah from Chloe Thanksgiving Day of 2020. Watch that video she made when she had to go back to get her daughter. The evidence shows that her condition deteriorated, the delusions not only continued, but got worse collectively over time, all building up to that day. We know that her mental state was broken, she was seeing things, she was hearing things, and the delusions were telling her over and over again she needed to die. Over and over and over again. Think about the pictures I showed you in the beginning of this case. The ones of her at 16, the ones of her in the summer leading up to this event. Ultimately, right before the event, where you can see where she is at that particular point in time. You can see the despair, you can see the stress, and you can see the mental illness in her eyes. See, there were signs that she was experiencing these delusions leading up to and on the day of the incident. There was discussions about death. She was seeing things associated with knives that she attributed special meaning to her because of that delusion. The 12 tribes, the dirty shirt. All of these delusions included the belief that she was sin, she was passing that sin on to her daughter, she needed to die, and Hannah was an extension of herself and her sin. She believed that Hannah was so connected to her and part of her that when she breastfed, she was imprinting and downloading all of herself into Hannah. She was experiencing these delusions in her mind that made her believe over and over again that she needed to kill herself and die. Based on her delusion regarding Hannah, she was thinking if she left behind her child, it would be a continuation of her sin and her false belief in that delusion that she was responsible for everything bad in the world. She needed to commit suicide. The act of suicide is what was driven by these delusions. It was not because of jealousy or anything related to Benjamin Ben Michael. Not at all. There's no evidence of that. The state told you in their opening that they were going to show that Ms. Driver was not mentally ill. I think they said crazy in air quotes. That Ms. Driver killed her daughter out of jealousy and some desire to be the only wife. She was not delusional. She just subscribed to some wacky religious conspiracy theories. And she was voluntarily part of this group and free to leave whenever she wanted to. There's been no evidence of that whatsoever. Let's talk about each one of these arguments and break them down. I'm not even going to address the assertion that they made in opening that she wasn't crazy. The evidence on its own speaks to that. There's no evidence that this event had anything to do with jealousy. There's no evidence that she killed her daughter because she wanted Benjamin to herself. The statements she made to law enforcement and hospital staff are not motives. She told Detective Cruz that she wanted a normal family. That's not an abnormal wish, but it's not a motive for murder. How does killing herself and Hannah achieve the result of having Mr. Ben Michael to herself? Or it's not logical. It doesn't make any sense, and it's not supported by the facts. She did not attempt to harm any of the other wives. She didn't attempt to harm Mr. Ben Michael. If she wanted to have him to herself, wouldn't she have gotten rid of the competition? If she was in her right mind, wouldn't she have taken steps to remove the others from the relationship? That seems to be a more logical response. Seems to me that she would have taken steps to stop those interfering with her wishes, not killed the child or herself. That argument defies logic. Jason also told us here there were no jealousy issues whatsoever within that group. Never any issues of Chloe acting out towards other women in the group or that she made any demands to have Mr. Van Michael to herself. Their own witness told you that. They were a happy family. They sat around talking about their feelings. They spent months trying to care for Chloe. There was no lack of attention. Killing Hannah and killing herself does not get Chloe attention. It does not get her alone with her husband. This was in no way a passive suicide attempt. If they had evidence to the contrary of how Jason portrayed their relationship in their life, state could have presented that to you. Ask yourselves why they did not. The state also argued that Chloe was free to leave at any time and not victim of domestic violence. And because she had access to money, she could come and go as she pleased, leave any time. They argued she could leave him with her daughter at any time. That argument goes against every ounce of training everyone sitting at that table has ever gone about the domestic violence cycle. There is evidence that Chloe had visible hearing injuries on at least 2 different occasions. They know from their everyday practice that victims engage in contact with their abusers despite knowing that they shouldn't be. They know their victims continue to contact their abusers, even when court orders are in place telling them not to do it. They continue to contact their abusers despite knowing what those people are capable of and go back to them repeatedly. They know that victims, in their experience, take steps to plan an escape, but they don't always execute that plan. They are trying to ignore the facts that are supported by their evidence that Chloe Driver was a victim of domestic violence, and she was trying to leave, and deal with that mental illness at the same time. They refuse to see her as a victim in this case because it just doesn't fit their narrative. I'm also just going to say this about domestic violence at the hands of Benjamin. Chloe was not his first, not his only, and certainly won't be his last victim. Gabriella told you how hard it was for her to break herself away from that relationship, both physically and emotionally. She told you about how controlling he was, the physical abuse she endured, the threats he made to her about leaving and never seeing her child again. You got to hear about that experience directly. You got to hear about the abuse, the control, the emotional connection, her feelings of worthlessness, and the difficulty from separating from him with a child. You heard her tell you that despite being subjected to all of those things, she would leave and come back to her abuser. It fits within the cycle of violence. It fits what happened in this case as well. You heard her tell you that it finally took her getting the strength and confidence and belief in herself and having the assistance of her family members to leave for good. And she never looked back. And what may seem relatively straightforward to us is inexplainable about why you would go back. You heard Detective Cruz here on cross-examination tell us in further detail just how hard it is for those types of relationships, especially with a child, to get away from their abuser. She talked to us about how it's not uncommon for women to return to their abuser, remain in contact, or try to find ways to leave, but just don't have the strength to do that. Both Gabriella and Chloe experienced significant trauma bonds with Mr. Van Michael. They both kept going back to what they knew, what they could expect, instead of moving forward into the unknown. That doesn't even take into account the emotional connection or underlying mental illness. Now, the state's probably going to tell you that whatever happened to Gabriella just doesn't matter. It's not relevant to what happened with Chloe Driver or her mental state. It is 100% relevant because Gabriella endured the exact same treatment and she sat here and told you about it. It was exactly the same as that was described to evaluators, to law enforcement, all by Chloe Driver. These two individuals never talked about their own experiences with each other. Gabrielle told you that she had one contact with her where she tried to explain some of the things she endured and realized that she wasn't getting through to Chloe. Detective Cruz was the one that contacted Gabriella 6 days after this crime had occurred because she knew exactly what she was dealing with based on her experience and following the evidence of their investigation. The control, the power, and the degradation of two women by Benjamin. Thankfully, Gabriella was able to escape and did not have pre-existing mental health issues. Thank goodness she was able to protect her child. In the presentation of this case, the state has always minimized what has happened to Chloe leading up to this. They didn't want to discuss her self-inflicted injuries. They didn't put any pictures of that up in evidence. We did. They didn't want you to talk about any of that. They didn't want to discuss the controlling and abusive relationship. They want you to believe that none of it matters in the context of this case. They want you to ignore her cries for help, her behavior leading up to this, the reports about the things she was saying to these people, and her attempts to leave on November 25th and November 26th. Now keep in mind, this case was investigated from the very beginning by Detective Cruz with regard to Ms. Driver's mental state and from the perspective that Chloe was a victim. As Detective Cruz began this investigation, she immediately suspected there was a lot more to the story than she was getting from these cult members. Long before Chloe could even have an opportunity to think of a defense. She sat in that hospital. She hadn't talked to anybody. Detective Cruz had already interviewed everybody. And based on that, you heard Detective Cruz tell you she had contacted other people. She had sought those Asheville police departments. She knew what she was dealing with. You watched videos where Chloe told you that she had been hurt and where Chloe told Detective Cruz about her black eye. She told Detective Cruz about her paranoia, her state of mind, and you saw the videos of her saying she wanted to die with that baby. Based on that experience with law enforcement with DV victims, she continued to investigate that case. She found additional women, she found those police reports, and more evidence of what that world that Chloe was living in. Now, you also heard from Jason Spillers, and that was quite a treat. He was able to paint a picture of this group in two very different ways. First, he was able to tell you about how he knew Chloe, how he knew her to be a loving, caring mother who loved Hannah and did everything for her. He knew her before she decompensated and spent so much time with the group that he knew exactly who Chloe was and what she was like. He told you about the different times he saw her, the changes he noticed, and even talking to Benjamin about getting her treatment. He told you that the group spent the better part of the last 2 months leading up to December 8th of 2020 taking care of Chloe. He told us about her episodes and how she would have these episodes or go catatonic and have no idea what had just happened. That there were dramatic changes just in the time that he knew her. And it wasn't jealousy. It was mental illness. Secondly, I don't know if he intended to do this or not, he painted a very clear picture for you of what life was really like in this group. You could see how he idolized Benjamin. He endorsed all of his beliefs and the life that came with it. It was clear that he and Benjamin viewed women as property, as lesser individuals. He told us that the women are subservient and that they were not capable of having the same conversations as men. I think he used the words, they should be off frolicking and dancing with the babies. He told us that, yep, Benjamin set the standard, and that is what everybody had to live by. He tried to paint a picture of this wild alternative reality that no one was buying about polygamy. We know that he disputed that incident with Sandra Torres. Think about this. If he punched a total stranger for attempting to help Chloe that day, can you imagine what these men do to these women behind closed doors? If Jason is that crazy, can you imagine how his leader is? Ask yourself why they did not let you hear from Benjamin. They didn't call him because they know exactly who he is. The facts of this case are undisputed, so let's get down to the experts. Now, we've all heard from 3 different experts in this case. They all agree she was severely mentally ill in the months leading up to the event. They all agree she was suffering from delusions at the time leading up to this. Dr. Garrett and Dr. Ballard both diagnosed her with schizoaffective bipolar disorder and borderline personality disorder. We heard this morning that Dr. Zom did not offer any individual diagnosis. That's just her approach to this. But she told you today that she didn't disagree with those. In fact, she agreed with them, maybe a slight variation. They all utilized the same resources and collateral information to conduct their evaluations. Both Dr. Garrett and Dr. Ballard told you that even outside of Chloe's self-report, the information provided among those sources of information was consistent and independently verified. Those doctors did not believe she was malingering or presenting in any way to achieve a certain result. The experts have told us that these delusions are defined as a fixed false belief that someone holds on to, even when the evidence shows that there's no way they can be real. They cannot be explained outside of mental illness. They are so unusual that they cannot be explained other than disordered thinking. That delusional compulsion that Ms. Gropper was talking about is defined as if that delusion had been real, it would have justified the conduct. Her delusions in this case were not religious in nature. She believed everyone was out to get her. She believed she had special powers. She believed she had magical thinking about things that she thought she did that impacted the world, that she was receiving specific messages directed at her. Those messages came both in auditory and visual hallucinations, but also those delusions of reference that were referenced by both of the doctors. Delusions are not things that are in line with a person's culture, and everybody knows them to be false. They are not extreme religious beliefs. A delusion that drove Ms. Driver to the point we're at today was the one that you heard from Dr. Garrett and Dr. Ballard and Dr. Zom, was that she needed to die. That is not part of any religious belief system. Those are not agreements for participation in any cult. All the experts agree on this. Now, I know you all sat here and paid attention to all of these experts, and I'm not going to go through everything that they have all talked about, but here's what I want to talk about with respect to each one of those. Dr. Garrett told us that the signs and the depth of her mental illness was ever present, that they existed before her relationship, and that she had been experiencing delusions since adolescence. That's important. That contradicts the state saying that she didn't experience delusions, that this is all made up. Dr. Garrett also told you that she was exhibiting those signs of those visual and auditory hallucinations even after being medicated for over a year and a half. When she met her, she was still exhibiting those signs of that delusional thinking. She was still having issues with suicidal ideation and thoughts that she needed to die. She told us it was clear she was experiencing emotional distress regarding the situation and confusion about the moral and ethical appropriateness of her delusions. She said, Ms. Driver said, I was at peace with how it was supposed to be. You heard that Dr. Garrett believed that she felt she needed to take her life because of her delusions, and everything in the world was telling her, in her mind, that's what she needed to do. Not just because of the delusions about sin, but because of all of those delusions of reference that she was seeing on a daily basis. That she was being told she needed to die. She would see a light bulb, she could see a knife, she could see all of these things that to you and I would mean nothing. But because of the disordered thinking and those delusions, it was feeding into her thought process and delusions. She told us that these delusions were above and beyond any religious teachings or anything that Mr. Ben Michael had ever told Chloe. Religious beliefs don't tell you you need to die. She also told you if you take someone who is vulnerable, who is already delusional, and bring them into this type of scenario and start teaching them crazy stuff, you are teaching them something that will only lead to an increase in their problems. Dr. Garrett also told us that Chloe started out as a very vulnerable young lady who was already delusional to begin with, having these thoughts. She also told us somebody that has a personality disorder, mood disorder, and substance abuse was her baseline. These things existed prior to her ever getting involved in this relationship, and that those circumstances only made this scenario worse. She also told us to think about this as not a particular moment in time. Ms. Gropper tried to ask her about the dirty shirt as a trigger, and Dr. Garrett quickly corrected her and said, no, you have to consider all of these signs. And she went through and she listed those signs. She told us that we have to look at this as a culmination of events, not something as a trigger. Now, Dr. Ballard came here yesterday and told us a lot of the same information that Dr. Garrett did. She diagnosed the defendant with the same illnesses and, in her opinion, believed the acts were driven by that thought process. She told us that some of the things that the state seems to believe were deliberate acts or tries to persuade you to believe were things that she premeditated and thought out in her head before doing it are actually acts in support of that delusional compulsion. They were acts that were in her mind to finish out what she was being told to do, that she needed to not die. Getting a knife and locking the door are acts that are can be attributed to carrying out that delusion, is a way to act on that compulsion that kept telling her she needed to kill herself. That's an explanation that's rooted in science and in psychology. She told us that these people in delusional states can do everyday things that appear like it's normal. She also told us that these Google searches show that Miss Driver was attempting to resist acting on those compulsions to the best of her ability. She sought ways out. She sought ways to get help. She was also able to explain to you from the psychological standpoint that the statements made by Chloe to law enforcement after the incident don't necessarily mean anything when you're talking about the mental state at the time of the crime. She also talked about the jail calls and continued communication that Chloe had with Mr. Ben Michael, and explained it in the context of not only Chloe's mental health issues, but in the context of her experiences while she lived in that relationship. The state played you a few phone calls in this particular case, all including her mother. What it tells us, based on those calls that you listened to, is the true depths of her mental illness and her entanglement to him. The jail calls you listened to still show that even when she was incarcerated, she was still controlled and manipulated by him. Notice how they didn't play any of the conversations with Mr. Ben Michael. She also told us that people who are mentally ill, who have not received therapy, who have not been properly medicated, make irrational choices. The jail is not a therapeutic environment, and that to treat all of Chloe's issues, a great deal of treatment was needed, not just medication, to break that bond. Her testimony, Dr. Zom testified today, really didn't dispute any of the other two doctors in this case. She told you that Chloe was suffering from the same type of delusions and mental illness in the months and leading up to this event. All the doctors are consistent with that understanding of her severe mental illness. They all agree that it was untreated, and based on their diagnoses, would only get worse the longer it remained untreated. Each of those doctors agreed that the delusions that Ms. Driver experienced grew more and more pointed to the idea that she needed to kill herself and ultimately her child. Dr. Zom also agreed that the specific delusions that Chloe was experiencing on December the 8th culminated in the final delusion regarding the dirty shirt, and that was a sign she was unable to overcome. Now, I just want to talk briefly a little bit about the treatment of the experts in this case by the District Attorney's Office, and I think that this needs to be discussed. Mr. Fogus spent a lot of time yesterday with Dr. Ballard trying to emphasize some perceived bias as a defense expert. Neither Dr. Ballard, nor Dr. Zom, nor Dr. Garrett have any interest in this case other than providing you an expert professional opinion regarding her mental state at the time the crimes were committed. They have all told you that their roles in these cases is not based on reaching a particular result. No defense attorney ever contacts them or contacts any expert and asks them, hey, we need you to do a particular thing for us. At the end of the day, all of the doctors who shared all the same title and the same qualifications, in essence, reached the same general ideas in this particular case. If any of these evaluators believed that she did not suffer from mental illness or had these delusions, none of us would be here today. This is just not how these evaluations work. Now, I think it's important when we talk about Dr. Monclendon that you all realize we called her as a witness in our case. The state didn't call her. She became involved in this case because she is employed by the Georgia Department of Behavioral Health and Developmental Disabilities. She works for the state. She was provided all of the information in this case that the state could give her to review prior to talking to Ms. Driver. Whether or not Ms. Gropper or Mr. Focus want to acknowledge it, she was their expert. And their expert agreed with Dr. Zahn and Dr. Ballard. She worked for the state. We didn't involve her in this case. We had no choice in Dr. Garrett. See, in response to our evaluation, Ms. Gropper sent a referral to the Department of Behavioral Health. Now, granted, Ms. Gropper doesn't get to pick which particular forensic psychologist is assigned to evaluate a defendant. But in this case, the state's own expert, the one who conducted the evaluation on behalf of the state of Georgia, sat up here and told you similar things that Dr. Ballard came in here and told you. Did you see Mr. Focus or Ms. Gropper attack Dr. Garrett personally when we called her as a witness? No. And she made very similar findings and told you about that here in court. If they didn't like any of the reports in this case, the state could have at any time in the last 3.5 years requested an evaluation by a doctor of their choice. I ask you this, would it have mattered? The answer to that question is no. They all agree she was severely mentally ill and suffering from these delusions. She needed to kill herself and her child. They just don't like that the experts don't align with their theory of this case. Now, the experts are hired to conduct an evaluation in the area of their expertise. They don't give you a particular result. It's not how the system works. Dr. Ballard told you she's done a lot of criminal responsibility evaluations, and maybe less than 10% of those evaluations have yielded an opinion of not guilty by reason of insanity. Dr. Garrett told you she works for the state of Georgia and testifies for both the state and the defense. And yet they came in here and told you similar things. If the Cherokee County District Attorney's Office believed that none of these doctors conducted a thorough and accurate assessment of Ms. Driver in the last 3.5 years, they could have done something about it. The state knows what we all know in this case, that if Chloe was in her right mind, she would never have killed that baby. If Chloe had gotten the help she needed, she would have never harmed her baby or herself. If Chloe had not been in an abusive, controlling relationship with a man more than twice her age, her already existing mental health issues could have been treated. There is absolutely no motive in this case to kill her daughter or herself. There is no reason other than what was related to those psychotic symptoms and delusions she was under on December 8th of 2020. It is now your job to set aside those emotions about the death of Hannah. The evidence shows at the time of the crime, she was not only suffering from delusions that were telling her she needed to die, but that she didn't have the ability to distinguish right from wrong. While in this delusional state, the experts told us that everything in her mind was telling her that she needed to die. There's evidence that showed she tried to resist giving in to these thoughts. There is evidence that showed she did not, in these delusions and altered states of mind, she didn't know what she was doing. She didn't know what right from wrong. There is evidence to show that because of her delusions telling her that she and Hannah needed to die, that she was overmastered by the constant voices telling her, you need to die, in her head, and ultimately acted on them. All of this started with undiagnosed and untreated mental illness that resulted in a truly horrible, tragic act. Let me put a few things in perspective that may have helped prevent this from happening in the first place. If Benjamin, Sarah, and Jessica or Jason had gotten Chloe help instead of CBD, or ignoring the reality that was right before their eyes every day, Hannah may still be alive. If the Asheville Police Department had arrested Jason and Benjamin on November 25th for the incident where they assaulted Sandra Torres that day, Chloe may have been able to get away and get the help that she needed, and Hannah may be alive today. If Brian had not taken Hannah from Chloe on November 26th of 2020, when he found out her parents were coming to get them, it's fair to say that she might have been able to break away from that relationship if he hadn't left with her daughter. Chloe was never going to leave without her daughter. You heard testimony from Chloe's mom about how she had no idea about the extreme nature of this relationship until it was too late. They didn't have any idea about the mental health struggles. She didn't confide in them because he had convinced her that she couldn't trust her own parents. Every single day, her parents live with regrets and think about those what ifs. What if they had just tried harder? What if they had called the police? What if they had just taken Hannah? It replays in their mind over and over again. Her parents still say, if we had tried harder to get through to Chloe, Hannah may still be alive today. Look at all the times that Chloe was unable to address these significant mental health issues. Those failures led to a deep and darker mental state. They caused Chloe to lose her way as a mother to this child. To that end, I agree with the state. She failed in her ultimate responsibility to protect her child. But the failure of her motherly duties was caused entirely by her untreated mental health crisis. It is clear that but for that paranoia, her hallucinations and her delusions, Chloe loved her daughter. And she fought in every way she knew how, and in the circumstances she was in, to resist those delusions to kill herself and her child. But when those things kept happening to her over and over and over again, and were so pervasive in her mind, that's all she could see. She tried to fight it. She was voicing these concerns to everyone. She was telling these people, let me be with her. Help me, get me help. We can see it on December the 8th. We can see that she was having these delusions, beginning with the 12 tribes, associating the discussion that they were having that day about death as a sign that reinforced that earlier delusion. We talked about the paranoia that she experienced at Whole Foods, the delusion about that room in the house, and being alone, and that ultimate final delusion of the dirty shirt that overwhelmed her ability, and she gave in. Now the court's going to give you instructions regarding the law for you to consider in this case. It is now your job to apply that law to the evidence that you have heard over the course of the last week. As Ms. Grauber kind of touched on briefly, you're going to be given a verdict form that allows you to decide this case in 4 different ways. The not guilty, guilty, guilty by mentally ill, or not guilty by reason of insanity. In order to find Chloe guilty of the charged offenses, you need to find that she committed the acts and that she had the required intent. And the state has to prove that beyond a reasonable doubt. The judge will charge you about what it means to find someone beyond a reasonable doubt. The option of guilty but mentally ill does not yield the same results as a not guilty by reason of insanity. And I want you to keep that in your head. A finding of not guilty by reasonable insanity, and the judge is going to give you an instruction on this, allows this court to maintain the custody and control over an individual for the evaluation and treatment of her mental health needs. And that can be indefinite. The law allows a person to be found not guilty by reason of insanity if they did not have the mental capacity to distinguish between right and wrong at the time of the crime. The law allows this because of mental disease, she acted in such a way that delusional compulsion overwhelmed and overmastered her will to resist. Now, we've all talked about the delusions and what a delusional compulsion really is, but in this case, she was compelled to act in this manner because in her mind, she believed she was right. She believed if the facts were as she believed them to be in her head, she was right. The testimony you've heard in this case was that these delusions were directing her to die. As evidence to show that she experiences these delusions of reference, these auditory and visual hallucinations, these command hallucinations, paranoia. You heard testimony that Chloe believed based on that delusion, she was downloading all of herself into Hannah and viewed her as an extension of herself. You heard Dr. Ballard tell you that people with these type of disorders have a very difficult time distinguishing boundaries or when one person ends and another begins. You've heard testimony that people suffering from the same illnesses as Chloe are often unable to distinguish the boundaries. She didn't necessarily know where Hannah began or ended. She didn't know where she began, where she ended. She viewed her in her mind as one unit. She was not going to leave behind any piece of her in this world to perpetuate that ongoing sin, which told her she needed to die. It is all part of the delusion. Now, the state began their opening statement, and again today, asking you for justice for Hannah. We agree. There is justice for Hannah in this case if you find her not guilty by reason of insanity. There is no doubt that our client committed these horrific acts. Never contested that. I want to be clear, though, that in this case, justice looks different than what we're used to. Our society has certain ideas about mental illness and has created a very strong perception that mental illness is an excuse for someone who commits a crime. The law recognizes that severely mentally ill people cannot perform the required criminal intent to commit a crime. The law allows you to find Chloe not guilty by reason of insanity if you believe at the time of the crime she was suffering from mental illness and that she did not have the ability to distinguish right from wrong. You're also allowed to find her not guilty by reason of insanity if you believe that due to her mental illness, she was suffering from a delusional compulsion that overmastered her will to resist committing the act. We know that Miss Driver was in a delusional state. She was confused as to what was right, what was wrong, and resisted acting on those delusions for a long time. In that type of mindset, in the throes of a severe psychotic episode, there is no way she had the ability to distinguish right from wrong at that time. And she was left untreated. And she got worse and worse. Now, Ms. Grobber talked to you a little bit about the delusional compulsion part of that, but we know from the evidence in this case that she was severely mentally ill, that she was suffering from delusions that compelled her to act in a particular manner. That if right, that would have been right if they had been as she believed them to be. If you find that Ms. Driver, based on those delusions, that she believed her actions were right, and as she believed them to be, she would be justified. The evidence has been clear that she needed to kill herself, and by extension, Hannah. She could not separate her identities at that particular time. Now, I want to tell you, suicide in and of itself is not a crime. In her mind, she was being told to kill herself and any part of her. Her intention, based on those delusions, is to follow through on that. And the delusions were telling her to commit suicide. Those right actions in her mind are what led to those events. As I told you, this case has always been about the why. And I think you just need to think about this in the context of how we got here today. Chloe was a young, naive individual with pre-existing mental health issues. She already walked in with that baseline to this relationship. She suffered years of abuse, coercive control, and a cult mentality. We've heard about she asked for help, she cried for help, and attempted to leave. We've heard that all the experts agree that she was suffering from severe mental health issues, and that untreated, undiagnosed individuals treating those type of illnesses get worse over time. They just don't go away. As we told you in the beginning of this case, mothers just do not kill their children. We told you to ask yourself what drives someone to do something like this to their baby and themselves. What drives someone to stab themselves 5 times in the neck and once in the heart? What drives someone to do this by someone who, all reports, loved and cared for that child in the most amazing way? And the only explanation is those severe psychotic symptoms and delusions she was experiencing. Now, I want to be clear. A finding of not guilty by reason of insanity does not mean that she walks out of this courtroom or is not held accountable for her actions that day. It means that she is committed to the state hospital to get the treatment she needs. Justice in this case for Hannah is getting her mother the treatment she so desperately needs. A verdict of not guilty by reason of insanity is not an excuse. It is a way the law allows an individual in Chloe's position to be held accountable based on those things. It is the why. It does not mean she's not held accountable. It does not mean there's no justice for Hannah. It means she gets the treatment and the help she needs. The only verdict in this case supported by the evidence to each and every count on that indictment is not guilty by reason of insanity to each and every count, because we have met the burden that we have that she could not distinguish right from wrong, and that she was overcome and overmastered by those delusional compulsions that in her mind justified that act. Thank you.
All right.
Ms. Trethaway just stood up here and said that if Chloe believed her actions were right, then she would be justified. That's not the law. And she's conflating the two different ways to prove insanity. Her ability to distinguish between right from wrong and delusional compulsion. The two don't overlap. Those are two different ways to prove insanity. If she just said to you, if Chloe believed in her mind she was justified, then she's insane. That's not the law either. And you don't have to believe me. The judge will tell you. The delusion, if true, would have legally justified the act. If we assume what was in her mind, it is legally justifiable under Georgia's self-defense laws. That's the law. It doesn't matter what Chloe thought was justified. The only thing that matters with regard to her distinction between wrong and right is the other part of the insanity charge, whether she had the ability to distinguish between right and wrong. When we're talking about whether the delusion was as to a fact, if true, would justify the act, we're talking about legal justification under the laws of Georgia, not about what Chloe Driver thinks about it. It's also important to me to address the fact that Ms. Trethaway indicated the state wants you to ignore all this stuff about her mental state. They just put up all this gory evidence to play on your emotions, even though Ms. Driver has never disputed the fact that she committed these acts. Except she has. She pled not guilty. We have the burden of proving the murder. I have to. It is my job. I'm not going to phone it in when we have a murder of a 13-month-old child just because I know her defense is insanity. I still, under the law, I have the burden of proving the murder. And I'm going to put up every ounce of evidence that I need to put up in order to do that. And that is not to play on your emotions. The fact that it was emotional, and the fact that it's horrific, and the fact that that body cam is going to haunt all of our dreams for a very long time is because of the actions of Chloe Driver, not because I'm trying to manipulate you. The state has a duty, and our duty is to represent Hannah. She was murdered in Cherokee County, and we have to prove her guilt beyond a reasonable doubt. And my presentation of evidence to you in that regard was following my oath. It was not to manipulate you or to convince you to ignore anything. I don't want you to ignore any evidence that came before you. Ms. Trethaway said, well, the state could have gotten another evaluation if they wanted to. None of the evaluations that have come before you meet the definition of legal insanity. Why would we keep asking for evaluations? It's their burden to prove insanity, and they haven't done it. Because none of the evaluations demonstrate that she doesn't understand the difference between right and wrong, or that she had any specific delusions that, if true, would justify the act, if true, would allow her to defend herself against Hannah. She could be evaluated by 10 more doctors. There's no evidence in this case that she meets the definition of legal insanity. And the state has never tried to pull the wool over your eyes, or ask you to ignore evidence, or ask you to be distracted. We have just asked you to focus on the actual issues in this case. And the fact of the matter is, it is their burden to prove insanity. It is not our burden. She is presumed sane under the law. It is our burden to prove the murder. It is their burden to prove insanity. I want to talk to you about some of the evidence that came before you. And one of the things that we need to talk about is Jason Spillers. I know everybody in the free world was questioning the wisdom of my decision to put this man on the witness stand and let him ramble on incessantly. I promise you it was not because I am a pea-brained female who is not capable of intelligent thought like Mr. Spillers would like you to believe. He provided some very valuable information, and he provided context to some things that you needed to have. There were statements made by Chloe Driver in this case about his new friends in the group, about her new existence, about how things had changed when he had gotten these new followers. Who do you think she's talking about? Old Crazy Pants. And he took this witness stand and talked about drinking his own pee, talking about all of his crazy views about women and their inferiority and how they're not capable of intelligent thought. And most of what he had to say was complete garbage. And I expect that most of what he had to say, you all will probably completely disregard. But what became very clear is that him and Benjamin had this little intellectual bromance. And they probably sat around and acted like they were the two smartest men who ever lived on the face of the planet, and things got different for Chloe and Hannah and the other women because Benjamin was in this little romance with his smart buddy, Jason Spillers, and the women were supposed to giggle and play and go do the things that women do because they're not smart enough to participate in intelligent thought. And so things got different for Chloe Driver, and she didn't like it. Those were her statements. You seeing it with your own two eyes, what her existence was, her wanting to get far away from Jason Spillers is not insane. That's reasonable because everybody in this courtroom felt the same way. They did not want to be around him because he was difficult to be around. And so he needed to come before you. You needed to see that with your own two eyes because it provides context to her statements about why she did what she did and why she was feeling the way she felt. And what were those statements? We knew that Jason Spillers was new to this group and that he had met Z in April of 2020. Chloe's been in the picture for 3 years, and it was just the last couple of months when things really went to go sideways. And it was after he joined the group. This is telling. He started spending a lot of time with them around July of 2020, and it definitely provided context for her statements to the detective. The first thing she wrote about why she did it, he didn't do it, I did it. I was going insane. I no longer wanted to be with his friends, but kept coming back for him. I only wanted my baby and husband, but he refused. When she said, I no longer wanted to be with his friends, she's talking about Jason Spillers. And you needed to see it. You needed to see it because her reasons and her motivation behind committing this act wasn't her delusions, it was her reality. It was the day-to-day life that she was subjected to, having to be around these two men. Her motivation was her reality, not her delusion. And you saw it. She told us why. When I stood up here in my opening statements, I said, pay attention to the why. It will help you solve the legal equation. It will help you put the pieces together. Why did she commit this act? This is when she was writing to Benjamin. No, I went to get a knife. I couldn't handle being with the group anymore, and you left me no alternative with certain threats of taking the money and not letting me just buy land and be with her as long as I needed. You had the whole group to take care of and blamed me for all the problems. These were her statements to Benjamin. She was fed up. She didn't want to be with this group. She didn't want to be with his friends. She wanted a normal life for her baby. She did not want him to keep recruiting more wives and more people to have to take care of and divide the attention even more. These were her statements. I just wanted to have a normal life for Nimsi. These were the very first statements that she was making to the people she cares about, her mom, Benjamin, and to the detectives in the case about why she committed the act. None of this is delusional. It is all very, very rooted in her reality, which was a living hell. These are her notes to the doctor that evaluated her shortly after she was hospitalized. I was stating for months I couldn't handle my husband's lifestyle anymore. She didn't want to be around all these people. He collects people to live with us, and after we got 3 more people, Sarah, Jessica, Jason, I started perceiving them as ganging up on me and leaving me out and changing stories. She's referencing the existence that was her reality. She is not referencing delusions. And you saw 4 hours from Jason Spillers, which was a little glimpse of what every day of her life must have been like. For the first 2 years, not so much, because it was just us traveling, but once he got people listening to him more, I started feeling scared and was begging for attention for us to be with the baby. These were the things that she wrote about why she committed these acts. They're not delusional. They're reasonable. Because wanting a husband and a child and not being in a cult, that's not unreasonable. That's not irrational. It's not delusional. That is a reasonable thought process. It was just the realities of her situation that she chose to commit the act she did because she could not deal with the reality of the situation that she chose to put herself in. The doctor who evaluated her in the hospital, patient felt the only way out was to kill her daughter and herself. He did not notate that she killed her daughter because of any delusions. He notated that her motivation for committing the act was because her and her daughter, it was the only way for them to get out. And that is not a delusion. And that is certainly not a delusion that, if true, would justify the act under the self-defense laws. This is not criminal insanity. This is her making a decision out of desperation because of the situation that was her reality. She told us why she did it. November the 25th of 2020, she Googled killing someone to save them. This is consistent with what all the doctors said about what she said about her feelings about Hannah. The last doctor, Dr. Zom, said essentially the overarching theme of things, whether they were rooted in her religious beliefs or rooted in her delusions, the overarching theme was, saving her daughter from a life of suffering. And that's consistent with what we know she Googled on November the 25th. And that is not a delusion that, if true, would justify the act. It is not insanity under the law. She was not motivated by her delusions or her insanity. She was motivated by her reality. And I think what kind of highlights that is, ironically, the testimony of Gabriella Kuykendall, Benjamin's ex-wife. She said it was difficult to leave. She said she doesn't have mental health problems and she thought about killing herself. It was a difficult existence that they found themselves in. And she wasn't delusional at all. She thought about just ending it. Not because of delusions, but because of reality. Because of the circumstances that they experienced. I want to talk to you about the evidence that demonstrates that she understood the ability to distinguish between right and wrong. Dr. Ballard indicated, when asked if she thought her behavior was wrong, Chloe Driver expressly said, "Yeah, as soon as it happened, I regretted it. I thought I shouldn't have done this. This was not supposed to happen. Dr. Garrett, she recalled apologizing to Hannah and told her daughter how much she loved her. I knew this was wrong from the beginning. These are the statements that she made from her own mouth to these doctors. And Dr. Zom, who testified last, said, that's not inconsistent with my assessment of the situation. You saw one of the first things that she wrote was, how long is my prison sentence going to be for killing her? It was very, very clear that she appreciated the consequences of her actions. She understood the wrongfulness of it, but she still did it. This was not an inability to distinguish between right and wrong. She chose to kill Hannah knowing it was wrong. And she said that out of her own mouth. Now, when we talk about the delusional compulsion, I gave you the law, and I want to just refresh your memory on it one more time because it was misstated by Ms. Trethaway. The defendant has to be laboring under the delusion at the time of the commission of the act. The criminal act itself has to be connected with the particular delusion, and it has to be as to a fact that, if true, would justify the act under Georgia's self-defense laws. And we talked about that. In order to justify the act, she would either have to believe that that force, that killing her was necessary to prevent serious bodily injury or death to herself, or to prevent Hannah from committing a forcible felony. There's zero evidence of that. There is no evidence and no possible way that this third rung of the delusional compulsion insanity defense can be met. Dr. Garrett, when she testified, she indicated she did not ask Chloe any questions about the cult dynamics or the conflict in the cult, despite the notes that Chloe wrote in the hospital, the ones that we just talked about, the ones that sort of demonstrated what her motivation for committing the act was. The doctor did not ask her about the dynamics of the group, did not ask her about the cult culture. She also did not ask her any details about the crime itself. She didn't give any details about what she was doing in that room, what the play-by-play was. If your inquiry is what was her state of mind at the time she committed the act, then the circumstances surrounding the act are really important. And Dr. Garrett instead said she didn't find it to be particularly relevant. She said, I asked her what she was thinking and how she was feeling. Except for Dr. Garrett is not her therapist. This is a question of legal insanity. It is a question of law. And Ms. Trethaway indicated that Dr. Garrett is the state's expert. Dr. Garrett works for a state agency in the same way that, like, a teacher might be a state employee. She's not the state's expert. We didn't hire her. We didn't retain her. The facts that came before you is I sent her a referral form after there was a court order for her to complete an assessment. Dr. Roberta Ballard is a private doctor that was hired by the defense. Then the state agency did an evaluation of her. Then an independent expert did an evaluation of her. That is all very common procedure in criminal cases. So when she says this is the state's expert, it is the state's expert in the context of she works for a state agency, but not the state of Georgia that is prosecuting this case. She is not affiliated with us. I want to talk to you about, I completed this chart with her on the stand. And I said, tell me what the delusions were. Give them to me. What did she say were the delusions? Because this jury is going to have to make decisions about what the particular delusion was that she was laboring under, whether it was connected to the act, and whether that delusion, if true, justified the act. That's your legal equation. And so we went through these. And so she indicated the particular delusions connected with the act of murdering Hannah was that everything was telling her to do it. People talking about death, thinking she should do it. Seeing knives. So let's play that out for a minute. Here's a knife. I see it. We're going to assume that everything in my head is true. And my head is telling me that everybody in this jury box is telling me to take this knife and go stab Mr. Focus. So if we assume that's true, that all 14 of you, 15 of you, are telling me, Katie, take that knife and go stab him. Do it. Take the knife. Go stab him. Would I be legally justified in doing that? No. Absolutely not. Just because the whole world and the whole room wants me to kill him it doesn't mean I'm legally justified in doing it. And that's what I mean when I say that if we assume it's true, it has to justify the act. And that's why it's really a narrow category, very narrow category of cases where the person that gets killed or harmed is perceived in their mind to be an immediate threat to them. Hannah would have to be an immediate threat to her. If Mr. Fogus, if I looked at him and I was having a distorted thinking or a delusional thought and I thought he was about to hurt me, and we assume that my delusional thinking is true, then maybe I'd be justified in defending myself and hurting him back. But that is not the evidence in this case. And none of these delusions, which ones, if true, would justify the act? And the answer is 0. There are none. Absolutely not a shred of evidence that she ever thought Hannah was a harm to her or anybody else. Dr. Ballard, when she was asked about things that Chloe Driver actually said close in time to the crime, which is the handwritten notes, I asked her about Mr. Fogus asked her about the handwritten notes. She indicated that it's misguided to assume that anything she said a day later is controlling. But the fact of the matter is, the legal question, is what her state of mind was at the time she committed the offense. Lots of people gain insight into their behavior and their actions and the things that they did as time goes on. But the pertinent question for you is, what was her state of mind in the moment that she committed the offense? So in that regard, don't you think that her statements close in time, her condition close in time, her mental state close in time is the most relevant? And she just disregarded it. The question is, what was her mental state at the time of the crime? I really do not want to revisit all of these body cameras gratuitously, but she is making statements and I need you to hear them. She has presence of mind. She understands the situation. She says repeatedly, let him be with her.
Please let him be with her. Please let him be with her. Please let him be with her.
Just get there 39, brother.
Please let him be with her.
Just get there 39. Come on.
Please.
Take him. Come on, go downstairs. Come on. We gotta
Tell you that quick now. Come on, quick.
She's not delusional. She's oriented. She knows exactly what's happening. She wants the baby's dad to be able to be with her when she dies. She understands the severity of the situation. She is mentally there. The EMT calls Hannah a boy, and she corrects him. Her.
Where's he yet?
She says it's a he, and Chloe says it's a girl. She has a severe presence of mind. She knows exactly what is happening in that room. She says, is that it? That's goodbye? She understands the consequence of her decision to stab that baby. She understands that her death is impending, and she understands the wrongness of her actions. And she shows us that in the minutes after she committed the act. She asks whether Hannah's still alive. She is not delusional or unclear about what she just did or why she did it. She has presence of mind. She understands the consequences. She understands the permanency, and she understands the result. Dr. Ballard focused primarily on Chloe Driver being a victim of coercive control. There was a lot of testimony about her being a domestic violence victim. And one of the things that Ms. Trethaway said that maybe just landed a little wrong for me is that, you know, everybody at this table, this goes against everything that they've ever been trained to believe about domestic violence victims. And the thing is, I've been a prosecutor for 17 years, and I've done nothing but crimes against women and children my entire career. And I've encountered a lot of domestic violence victims. And I've never stood up here and told you that Chloe Driver didn't experience domestic violence. I have never said that, and I'm not going to say that. What I have said is that Chloe Driver didn't experience any domestic violence in Cherokee County, so we have nothing to prosecute. We have jurisdiction over the crimes that were committed in Cherokee County, which was the murder of Hannah Driver. And the other thing I know about domestic violence victims is they don't get a free pass under the law to murder their children. No matter how bad their situation is, the law still has to apply to them. Just because they have experienced something terrible in their life does not give them the right to murder innocent, defenseless little children. And that is not because we don't care about domestic violence victims. It's because the matter before us and the crime committed in Cherokee County and the relevant issues in this case are not domestic violence. They're murder of a child. It is clear that some of these experts and the defense really don't place any responsibility on Ms. Driver at all for any of her actions. And it's something I ask you to consider and think about in the context of a cult. Because in theory, if there is one cult leader and then there are all these cult followers, are we to believe that any criminal actions by anybody who joins this cult, they are no longer responsible for it? They don't have to answer for their choices and their decisions because there's one person that's manipulative and controlling at the top. So now all of a sudden everybody has absolved themselves of criminal responsibility and free will. But that is not the law. You cannot join a cult or an oppressive situation or be in an abusive relationship and now the law no longer apply to you. You still have to answer for your decisions. You still have to suffer consequences of your criminal actions. The judge is going to tell you that the evidence that came before you about the abuse of Chloe Driver by Benjamin is really only relevant to for a very narrow reason. And the state was not trying to ask you to ignore anything or distract you or have you look away from things. It's just really not the question before you, whether or not she was abused. The judge is going to tell you that the only relevant purpose for that testimony is whether or not it sheds light on her mental state. That is relevant to her insanity defense. So to the extent that her abusive, controlling, oppressive situation, we've never said she didn't experience those things. She probably did. It's just not really the issue before you to diagnose or decide. But to what extent do those things have an impact on her mental state? And what I want to tell you is the defense expert kept using the term coercive control. And the truth is coercion is not a defense to murder under the laws of the state of Georgia. So the only thing you're concerning yourself with in this case is whether or not she meets the definition of insanity under the law. And even if you take these abusive events and you think about, how they might have impacted her mental state, you still have to determine whether she meets the definition of insanity. You still got to go back to those two tests. Could she distinguish right from wrong? And was she suffering under the compulsion of delusion that, if true, would justify the act? So even assuming that you believe she was this oppressed victim of domestic violence by Benjamin and you believe all the stuff about what her treatment was probably like, she still, in order for it to be a defense, has to meet the definition of insanity under the law. So you have to put that evidence about her treatment by Benjamin into the proper context, and the judge will tell you the only context that it is relevant to in this particular case in terms of solving the legal question before you is to what extent you think that impacted her ability to distinguish from right from wrong, and to what extent that impacted her delusions that were connected to the act that, if true, would justify the act. And once you kind of do the math and do the equation, you will arrive at the conclusion that none of the delusions would justify the act legally, and that she clearly understood the permanency of her decision and the consequences of her actions. Dr. Dr. Ballard also did talk a little bit about her diagnostic testing, and I think this is important to discuss. Ms. Driver had an invalid score on her assessment, and she over-endorsed and over-reported symptoms. And so there was questioning by Mr. Fogus about that, because that's obviously concerning in the context of a forensic evaluation when the test scores essentially show that she's exaggerating. And it showed that she had very high scores and that she had a motivated response. But when asked about it, the doctor basically indicated, well, it could mean that, you know, she's trying to get herself out of trouble, but I just interpreted it as a cry for help. She chose instead to interpret it as she's just piling on all these extra symptoms and exaggerating her symptoms because she's desperate for help. But the fact of the matter is she's already in the jail, she's already receiving mental health help, she's already medicated, she's already away from him even though she's continuing to reach out to him and call him. So why did this expert choose to discount the possibility that Ms. Driver was potentially exaggerating her symptoms to benefit herself in a criminal case and instead just chose to call this a cry for help? It's something to consider with regard to Ms. Driver, because we know some things about her. She's not dumb. She has above average intelligence according to the last expert. She manipulated the doctors and the jail staff in order to get access to an unrecorded office line where she was supposed to speak to only her lawyer and her mother when she is in jail for murder. And she uses this unrecorded office line and abuses those privileges to continue to call him. Of course, once it's detected by us, they immediately revoke her privileges and put an end to it. But then what does she do? She continues to communicate with him after his number has been blocked by the jail and intentionally does not share that information with the doctors that are evaluating her because it doesn't fit into the narrative that she's desperately trying to escape him and she's being held against her will. The state has never said she wasn't a domestic violence victim, but this narrative that she was held against her will and she couldn't leave and she had no access to money and he would take her phone, it's not true. Maybe he was controlling her mind, but the undisputed evidence is she had a phone in her bag, she had $1,000 in her bag, she had spent 2 days at her parents' house just days before she murdered her daughter. She didn't say anything to her parents about wanting to go get mental health help or thinking about killing her baby. Ms. Trethewey stood up here and said, well, all these people could have done something to prevent it. If Jason and Benjamin and Sarah and Jessica would have just gotten her help. But she was at her parents' house for 2 days. Right before this happened. That video on November the 27th when she said, he has my baby against my will, she went to her parents' house after that. That's what the evidence was. And she said, Ms. Trethewey stood up here in front of you and said she was not going to leave him without her baby. She had to go back to him. She was not going to leave him without her baby. The evidence is she was not going to leave him, period. Because her baby was dead. She murdered her baby. And then she continued to communicate with him for over 2 years. Murdering Hannah in her rational, medicated, stable state, understanding she murdered her own child, she continued to reach out to him and call him over 600 times. This wasn't about Hannah. Hannah could not be held over her head. Hannah could not be stolen away by Benjamin. Hannah was gone. Hannah was dead. And she still made that choice. And the thing is, there are consequences for choices. If you want to get away from somebody, there's no better place than the county jail. Because he can't get in and he can't call you. But she found ways to get to him. She convinced 6 other inmates to use their phone pins for over 2 years so she could continue to contact him and had 617 calls. All of this was while she was medicated and stable and not delusional. She learned from the best in terms of her ability to manipulate the process, manipulate the system. The evidence in this case is that these groups were fraudsters by trade. They had plans to go steal houses that were bank-owned on Zillow. They had taken out all these COVID loans. They didn't have any insurance. They had all this trust documentation.
They found out ways to get free cars. They had tons of money. None of these people had jobs, and they had a ton of money in the bank because they would just lie, cheat, and steal from the government in a way that benefited them. And the questioning of Dr. Zom at the end was, oh yeah, she understood. She knew the inner workings of how to game the system. She was very, very educated and knowledgeable about it. She told Dr. Zom she was 80 pounds when she entered the hospital, which was a under-report of 33 pounds from what her actual weight was. And maybe that's not a significant fact to you, but it's just a fact that's not true. It's just something that's not supported by objective, independent evidence. And so it's something to pay attention to. What is her motive in this case? How is she attempting to paint herself despite her intentional, repetitive conduct to the contrary? She had a conversation with her father just prior to being evaluated by Dr. Zom, where they discussed that she would be screwing herself if she acted normal in that evaluation. Those are things for y'all to consider. What she has to gain or lose in this case. What she might have to gain from over-exaggerating her symptoms. And why her statements at the hospital, when she was at her lowest, and she was sad, and she was raw, and she's just telling it, why those statements are really the more credible statements about what motivated her act. What did every expert agree on? Every single one. Dr. Zom, Dr. Ballard, Dr. Garrett, they all said she never believed Hannah was a threat to her or anyone else. And because of that, the third prong of that delusional compulsion insanity defense cannot and will not be met. So why did she do it? I've thought a lot about that, and I'm sure you have too. What was the prevailing emotion when she gave in and decided she was going to end it for both of them? Was it desperation? Was it anger at her situation? Was it a mercy killing? Was she saving Hannah? Did she just feel hopeless? Was she mentally ill? It's not the insanity defense. If this is what you think any of her motivation was in committing the act, none of those are insanity under the law. Because no matter how hopeless you feel, no matter how desperate you feel, no matter how angry you feel, no matter how frustrated you feel, you don't get to commit the act of murder. And that is the law. What does the evidence actually show in this case? This was not a fleeting moment of insanity. It wasn't. The evidence shows that she thought about it, and she planned it. She had searched how to snap a neck. She had searched killing someone to save them. And you'll have her searches back there, and you can go through them, and you see the progression, because on about November 22nd and 23rd, she starts questioning the ideologies of the group. Am I sinning? Like, should I be with this man that has multiple wives? She's starting to question her reality. She's not questioning her delusions, she's questioning her reality. And then she starts to wonder about what the consequences of those certain things are. None of those are delusional. And then she starts to plan her exit strategy. And the evidence is she was weighing her options. She was Googling, and you can look at her phone and see, she was Googling travel plans. She was Googling bus tickets. How to get a bus ticket for a 13-month-old. Woman traveling alone with baby. She was evaluating the other options. She was thinking about leaving. She was desperately tied to him and loved him. And as I said in my opening statement, she could not decide if she wanted to stay or go, so she picked a different option. And that is what the evidence shows. She was so desperate to not know which one she wanted that she just decided to end it for both of them, except for she was unsuccessful for herself. She was at her parents' house for days between when she Googled those thoughts of wanting to kill Hannah and when she actually killed Hannah. That's what the evidence is. So she wasn't deprived of the ability to get the help she wanted. She just wasn't ready to give him up. Her mom said she stayed for a couple of days and then she went to look at some property with him in Knoxville. And we know she wasn't ready to give him up because she stuck it out with him for years, even after she killed Hannah. If killing your own child doesn't wake you up, What does? She made those choices. She was not a captive. She had the ability to go. She had the ability to call 911. She had the ability to access money. That's what the evidence has been before you. She chose not to. This is ultimately what the evidence in this case shows. She was not motivated by her delusions, her insanity, or her mental illness. What she was motivated by was her reality. And it was a reality that she chose over and over and over again. I'm asking you to hold her accountable for what she did to Hannah. Because while there may be some evidence that she's suffered a difficult life or that she's experienced certain things, that does not give her the right to take away the life of a 13-month-old child. That does not give her the right to stab that baby girl who did nothing to her repeatedly. There were so many other choices. So many other choices. And she chose that. There have to be consequences under the law for killing defenseless, innocent children. And when you apply the law, when you do the legal formula, when you look at the insanity laws, you will clearly see she does not meet them. And that the only true verdict in this case is one that holds her responsible for her actions, just as anybody else who committed an act like this would be, to find her guilty. This is the last place that Hannah experienced life. She stabbed this baby girl to death until what the ER doctor said, she was empty. She had no blood left. That was a violent, heinous, horrible way to die. And I don't care how bad your life is, you do not get to do that to this baby girl. And there be no consequences for you. She chose that life. Hannah did not. Hold her responsible. Apply the law. Apply the law in a reasoned way that doesn't play into sympathy, that is objective, that speaks to justice. That is your duty. And when you apply the law and you objectively evaluate the facts in this case, the only conclusion that you can reach is her guilt.
Thank you. Members of the jury, then the next phase of the trial will be that I will instruct you on the law that you should apply to the evidence that you've heard in this case. However, we're going to let you take a recess before I do that. I had mentioned to you at the beginning of the trial that you are not allowed to have any kind of electronic device with you in the jury room during deliberation. So if you have phones, laptops, tablets, anything of that nature with you in the jury box or in the jury room, please remove them from the jury room. You may take them to a vehicle. You may give them to the bailiffs, who will have a box outside the deliberation room so that you can access them during breaks if you would like to. Leave us your notepads. Don't start talking about the case with each other. You have not heard the law that applies from the court yet, and we will see you back, we'll say at 20 till. Be back in the jury room at 20 till 4. Members of the jury, you are considering the case of the State of Georgia versus Chloe Alexis Driver. The grand jury has indicted the defendant with 1 count of malice murder, 2 counts of felony murder, 1 count of aggravated assault, and 1 count of cruelty to children in the first degree. The indictment reads as follows. In the Superior Court of Cherokee County, the grand jurors selected, chosen, and sworn for the County of Cherokee, and they are named in count 1, in the name and behalf of the citizens of the state of Georgia, charge and accuse Chloe Alexis Driver with the offense of malice murder. For that the said accused, on or about the 8th day of December 2020 in Cherokee County, Georgia, did then and there, unlawfully, with malice aforethought, cause the death of Hannah Nicole Driver, a human being, by stabbing Hannah Nicole Driver in the neck with a knife, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 2, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Chloe Alexis Driver with the offense of murder. For that the said accused, on or about the 8th day of December 2020 in Cherokee County, Georgia, did then and there, while in the commission of the offense of aggravated assault, a felony as alleged in count 4 of this indictment, caused the death of Hannah Nicole Driver, a human being, by stabbing Hannah Nicole Driver in the neck with a knife, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 3, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Chloe Alexis Driver with the offense of felony murder. For that the said accused, on or about the 8th day of December 2020 in Cherokee County, Georgia, did then and there, while in the commission of the offense of cruelty to children in the first degree, a felony as alleged in count 5 of this indictment, caused the death of Hannah Nicole Driver, a human being, by stabbing Hannah Nicole Driver in the neck with a knife, contrary to the laws of this state, the good order, peace, and dignity thereof. And in count 5, the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Chloe Alexis Driver with the offense of cruelty to children in the first degree. For that the said accused, on or about the 8th day of December 2020 in Cherokee County, Georgia, did then and there maliciously cause Hannah Nicole Driver, a child under the age of 18 years, cruel and excessive physical and mental pain by stabbing Hannah Nicole Driver in the neck with a knife, contrary to the laws of this state, the good order, peace, and dignity thereof. It has been filed on behalf of Shannon Wallace, the elected district attorney, on March 8, 2021. The defendant has entered a plea of not guilty to this indictment. The indictment and plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. I will interject here that this is not a gender-specific charge, and sometimes I'll be saying he and sometimes I'll be saying she, but I am referring to the defendant, Ms. Driver, in this case, in these instructions. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and the exhibits admitted during trial. Evidence also includes stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. It does not include the indictment, the plea of not guilty, opening statements or closing arguments by the lawyers, or questions asked by the lawyers. The parties have entered into a stipulation that has been approved by the court. When parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is a proof of set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility or believability of the witnesses. In deciding credibility, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their intelligence, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the case, and their personal credibility as you observe it. Testimony has been given by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based on that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of her constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent the defendant was informed of her rights as discussed below. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement officers are as follows. The defendant had a right to remain silent. If the defendant chose not to remain silent, anything she said could be used as evidence against the defendant in court. The defendant had a right to consult a lawyer before any questioning and to have the lawyer present with her at all times during any questions. And if the defendant did not have money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant, offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by other evidence beyond a reasonable doubt that the crime alleged has been committed may constitute supporting evidence of a defendant's statement, if any, should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify conviction. If you find that there was a statement made by the defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of the defendant beyond any reasonable doubt. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. The defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. The law provides that criminal actions shall be indicted in the county in which the crime was allegedly committed. Venue, that is, whether a crime, if committed, was committed in Cherokee County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue must be proved by direct or circumstantial evidence, or both. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act and moved the defendant to do the act, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or the lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Count 2 of the indictment alleges the commission of felony murder based on the alleged commission of aggravated assault. Count 3 alleges the commission of felony murder based on the alleged commission of cruelty to children in the first degree. Aggravated assault and cruelty to children in the first degree are felonies, and I will define them for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault or the felony of cruelty to children in the first degree, as alleged in this indictment, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed or attempted. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether a knife is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the character and capabilities of the weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of the case. For cruelty to children in the first degree, the state must prove that the defendant maliciously caused cruel or excessive physical or mental pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that pain may result. The act of committing suicide is not unlawful in Georgia. Only the act of assisting another person's effort to commit suicide is unlawful in Georgia. Every person is presumed to be of sound mind and discretion. However, this presumption may be rebutted. If you find that at the time of the alleged criminal act, the defendant was suffering from insanity or mental illness, then you shall determine whether the defendant is not guilty by reason of insanity, guilty beyond a reasonable doubt, or guilty beyond a reasonable doubt but mentally ill. The law makes a distinction between being insane at the time of the commission of the alleged criminal act and being mentally ill at the time of the alleged act. Therefore, it is necessary for you to understand this distinction. A person shall be found not guilty of a crime if at the time of the act constituting the crime, that person did not have the mental capacity to distinguish between right and wrong in relation to the act. In regard to the question of sanity or insanity at the time of the alleged criminal act, there is a test to determine whether the person is suffering such a degree of insanity that the person is not capable of committing a crime. The test is whether the insanity was such that it deprived that person of the mental capacity to distinguish between right and wrong in relation to the act that the person allegedly committed. The perpetrator may be what is commonly referred to as insane in a loose and general sense, yet in the eyes of the law, she may be sane and responsible so far as the act in question is concerned, if at the time of the commission of the alleged act, the accused had sufficient capacity to distinguish between the right and wrong of the particular act. This is a question of fact to be determined by you, the jury. Mere weak-mindedness, mental abnormality, or mental state shown only by repeated unlawful or antisocial conduct, which does not amount to insanity, is not a defense to a crime if the person had the mental capacity to distinguish between right and wrong in relation to the alleged offense when the alleged offense was committed. Insanity may be only a temporary malady, and if the accused did not have sufficient mental capacity to distinguish between right and wrong with reference to the act alleged in this indictment at the time that the act was committed, then the accused would not be criminally responsible. The test of criminal responsibility is the condition of the mind of the accused at the time of the commission of the alleged act. If a person of unsound mind has intervals of understanding during which that person can distinguish between right and wrong of a particular act, then that person shall answer for that act if it was committed during those periods of understanding. If, due to an affliction of the mind, a person's mind is so impaired that the person is incapable of forming the intent to commit the act with which she is charged, or to understand that a certain consequence would likely result from the act, then that person would not be criminally responsible for the act. The defendant has the burden of proving insanity by a preponderance of the evidence. If you believe beyond a reasonable doubt that the defendant committed the act charged in this bill of indictment, but also believe by a preponderance of the evidence that at the time of the commission of this act, the defendant was mentally incapable of distinguishing between right and wrong regarding this act, then it would be your duty to acquit the defendant because of insanity. I have already defined for you what beyond a reasonable doubt means. Now I will define for you what a preponderance of evidence means. It means evidence on the issues involved that is sufficient to incline a reasonable and impartial mind to one side of the issue rather than to the other. Proof by a preponderance simply requires that the evidence show that something is more likely true than not. If you find the defendant not guilty by reason of insanity, then you must specify this in your verdict, and your deliberations cease. In that event, the form of your verdict would be, we the jury find the defendant not guilty by reason of insanity. Should you find the defendant not guilty by reason of insanity at the time of the crime, the defendant will be committed to a state mental health facility until such time, if ever, the court is satisfied that she should be released pursuant to law. There is an exception to the rule that I have just given you. If a person has sufficient reason to distinguish between right and wrong as to a particular act about to be committed, but because of some mental delusion, the person's will was overpowered so that there was no criminal intent to commit the act in question, that person cannot be held criminally responsible for that act. In that regard, a person shall not be found guilty of a crime when, at the time of the act constituting the crime, that person, because of mental disease, acted because of a delusional compulsion that overpowered the person's will to resist committing the crime. In order for mental delusion or delusional compulsion to constitute a defense, it must appear not only that the accused was actually laboring under a delusion at the time of the commission of the alleged criminal act, but that the alleged criminal act itself was connected with the particular delusion under which the accused was then laboring, and that delusion was as to a fact that, if true, would have justified the alleged act by the accused. This is a question of fact to be determined by you, the jury. Justification is defined as follows. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when she reasonably believes that the use of such force is necessary to prevent death or serious bodily injury to herself or a third person. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. Reasonable beliefs are explained as follows. For the defendant's use of force to be justified, the defendant must believe that her use of force is necessary. That belief must be reasonable. That is, a reasonable person would also believe that the use of force is necessary, and the defendant's reasonable belief must be what prompts her to use force. Evidence of acts of violence against the defendant perpetrated by a third party have been admitted into evidence. If you find from the evidence that the defendant suffers from battered person syndrome, you may consider such acts to the extent that they relate to your assessment of the mental state of the defendant at the time of the commission of the offense. If you believe this defendant committed the act charged in this bill of indictment, but at the time the defendant was actually laboring under a mental delusion and that act was connected with that delusion, then you should find the defendant not guilty because of insanity. In this event, your deliberations will cease and the form of your verdict would be, we the jury find the defendant not guilty by reason of insanity. I charge you that if you should find the defendant not guilty by reason of insanity at the time of the crime, the defendant will be committed to a state mental health facility until such time, if ever, that the court is satisfied that she should be released pursuant to law. If, and only if, you do not find the defendant not guilty by reason of insanity, then you may consider whether or not the defendant was mentally ill. As to being mentally ill at the time of the act alleged in the indictment, the term mentally ill means having a disorder of thought or mood that significantly impairs judgment, behavior, capacity to recognize reality, or ability to cope with the ordinary demands of life. The term mentally ill does not include a mental state shown only by repeated unlawful or antisocial conduct. Under the evidence in the court's instructions, if you find and believe beyond a reasonable doubt that the defendant is guilty and was mentally ill at the time of the commission of the offense, then you would be authorized to find the defendant guilty but mentally ill at the time of the crime. If this is your finding, then you must specify it in your verdict, and the form of your verdict in that event would be, we the jury find the defendant guilty but mentally ill at the time of the crime. I charge you that should you find the defendant guilty but mentally ill at the time of the crime, the defendant would be placed in the custody of the Department of Corrections, which will have responsibility for the evaluation and treatment of the mental health needs of the defendant, which may include, at the discretion of the Department of Corrections, referral for temporary hospitalization at a facility operated by the Department of Behavioral Health and Developmental Disabilities. Any evidence as to the insanity of the defendant is to be considered by you along with all of the other evidence in this case. If the evidence as a whole raises a reasonable doubt as to the defendant's guilt, that doubt must be resolved in favor of the accused. I think you're going to have, if you would help me out with the verdict form. You can see, you will have the verdict form with you in the jury room, but as you will see, you have all your choices laid out for you as to each count, and you should follow the directions that I've just given you as to how you make those determinations. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Cherokee County, Georgia, did commit the offense as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Those two options are options A and C on the verdict form. And then I have also explained to you the law as it pertains to your options B and D on the verdict form. Whatever your verdict is, it must be unanimous. That is agreed to by all of you. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations, and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an honest opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon whether the defendant is guilty or not guilty. You are only concerned with determining whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. Your verdict should be a true verdict based upon your opinion of the evidence according to the law as given you in this charge. You are not to show favor or sympathy to one party or another. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. As I said, your verdict, whatever it is, must be unanimous. It must be in writing. It must be signed by one of your members as foreperson, dated, and returned to be published in open court. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a cell phone, laptop, tablet, or computer, to communicate to anyone any information about this case, to receive any information about this case, to conduct any research about this case, or for any reason until I accept your verdict. We do have 3 alternates, and those are numbers and 201, and we will ask that you remain right outside the door there, and we'll call you back in for some further instructions. Now, all the rest of you may retire to the jury room. Do not begin your deliberations until all of you are present, till you have received the indictment, a copy of these jury instructions, and all of the evidence in the case. So you may be excused. What you've already noted.
I will say that I think the court ordered some of it out of the order that we have it in the document, but I think it was all.
Sometimes pages stick together. Okay. I've got the indictment with the witness list torn off. I have the charge. I have the verdict form. Have y'all agreed on what evidence is going out?
I just need to go, if I can be excused, Judge, to the indigent defense office. We're going to try to print that extra picture off and
Okay.
add it to the.
In the meantime, is there any objection to the alternates being excused, subject to being called?
No.
All right, we'll bring in 108, 94, and 201. If you just want to review that. All right, 108, if you'll raise your hand. Okay, 94 and 201. All right. Sometimes I say that being an alternate juror is like being first runner-up in a beauty pageant. You don't get to serve unless somebody ahead of you is disqualified. So we don't ask you to remain with us. We will let you be excused if you can give the bailiffs a phone number where they can reach you, and you could be back here within a half hour. Don't get further away from us than that, because we would need you to return to us if anything happened to any of the other jurors before a verdict is arrived at in this case. So if you can do that, we will let you be excused. You will be excused subject to all the same directions that I've been giving you throughout the trial about not reading any media reports, doing any research, having any conversations with anybody, but you can be at least a little more at leisure as we excuse you. We will tell you when the verdict has been reached and when you are finally excused from your service. We appreciate your cooperation and your service in this case. But you can step out and give the bailiff your phone numbers, and we will let you know as things transpire. don't intend to go particularly late tonight. I certainly don't expect, well, you never know, but I don't expect there to be a verdict tonight unless we held them here, which I am not inclined to do. So probably sometime between 6 and 6:30, if we haven't heard from them already, there haven't been any questions or any other word from them, then I'll bring them back in and we'll excuse them. So,
Judge, may we be at ease with them?
you can be at ease, let's say 6:15. I'll give them an hour and a half unless we, as I said, unless we hear from them earlier. The question is, what is meant by a third person? Is it a specific person or people in general? I believe that there's reference to a third party or third person.
Mattered person.
Also in justification, I think.
And battered. It also came up in the context of Dr. Zom, I believe. I don't know that I've ever done this before, but can we ask them to be more specific? Because I know that it's in several contexts.
Maybe ask which specific charge they're asking about. Yeah.
I'm sorry?
In relation to what? Maybe. What y'all think about that?
Yeah, I mean, yeah, because I think in the context of what it's related to, it makes a difference. How the response is, or it's just third person is a third person.
Do you object if I write that on this question and send it back, or do you want to just bring them in and let me ask them?
No, I don't object just to write it on there. I don't think that's an issue.
I have an opinion. Ms. Gropper and Mr. Fogus.
I have no problem if you just want to write it on there and send it back.
Mr. Bailiff, if you don't mind showing council what I've written, and then you can take it back. Thank you, sir. answer is page 15 under second criteria to justified, which is so. To prevent death or serious bodily injury to herself or a third person. Anyone other than herself? I think it's. All right, let's bring them in. Another person? Any. Yeah. The justification charge may merit some plain English updating. Members of the jury, we've received your question, and we'll just go over that portion of the charge that you've identified in your question. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, one, he or she reasonably believes that the use of such force is necessary, two, to prevent death or serious bodily injury to herself or a third person. You are asking what third person refers to? That okay. And that is another person. Another person other than herself. Does that answer your question?
May I ask a question?
You may.
Does that person need to be present in the space where the act is taking place?
I cannot answer that directly. It is addressed in the charge as a whole. I'm not trying to be vague, but there's certain answers I just can't give you. Any other questions? All right, we're going to let you keep going for a little bit longer. We're not going to stay particularly late, but I'll excuse you to continue your deliberations. excuse them for the evening. Hey.
No objection.
All right, let's bring them in. All right, members of the jury, it's time for us all to go home for the evening. I am going to ask that you return tomorrow morning at 9 o'clock. Once everybody is here, you can resume your deliberations, and I won't bring you back out. Just don't begin deliberations until everybody is present in the jury room tomorrow morning at 9 a.m. As always, do not gain any information about this case from any source. Don't talk to anybody. Don't look anything up. And we will see you tomorrow morning at 9.